What it do, chat? Shout out to E Capone. How are y'all doing? Happy Friday. We are popping in, giving you an update on the Julio Foolio murder trial. Man, oh man. It's going to be interesting because the defendants, I have been poking around in the case file, and it looks like one of them might be severed. All right. So we're talking about Rashad Murphy, Davion Murphy, Sean Gaithright, and of course, Isaiah Chance Gutazay, who is Alicia Andrews' baby daddy. Okay. So keep track of all this because what's going to happen, and we verified in the last stream that the boys are going to trial in as early as, I think, May 6th, May 4th or 6th. Yes, May 4th. May the 4th be with you. So we are starting that trial on the 4th. However, looking at Davion's case file, we have his trial starting, I think, the 6th. So let me see if I can pull that up. That's how we'll start this stream, actually. Because I was in there yesterday. I said, why are his dates earlier than the rest? Well, the reason why is it's likely that he is the first to go and is going to have a severed case. So let's check this out over here and we'll take a peek at it. But if you could look at Davion's case file here, right? On the top of the screen, and this was just put up there like yesterday in his schedule. It starts as early as April 8th, okay? And it says jury trial. They're only giving it 5 days. So you have the 8th, the 9th, the 10th, the 13th, the 14th, and the 15th. So that starts on a Wednesday and goes into the Wednesday of the following week. Now, here's the other important thing when it comes to this. We have another hearing that took place on Tuesday. The last time we were live was actually this past Tuesday, and all of the defendants came in for Judge Sisco to review some of their motions, last-minute motions before trials. Now, they did have another hearing that Tuesday that was not televised, but the recording came out the day after. There's currently a hearing happening right now. I'm going to see if they post it, but what we can do in the meantime is check out some of the decisions that Judge Sisco made, because this past Tuesday, she made some decisions. And I heard that it was a heavily denied date. Now, the boys should be worried because we've been running a poll like if they're cooked or not, right? I mean, Sean and Isaiah, there's just no way. Like, they're done. But the Murphy brothers is going to be interesting. The other big development is that Rashad I think Rashad is still trying to get out of this. He also filed a motion on the 5th, right? So this came out yesterday as I was reviewing his case file. It's a supplemental memo in support of severance of the defendants or in the alternative for separate juries. Remember, there's 3 death penalties on the table, okay? So Rashad filed this yesterday. He's still trying to get out of it. Still trying to get out of it. Y'all do me a favor, hit the like button as you join. We are going to be here for about 2 hours. That's how long this hearing is. This is the Tuesday hearing. Without further delay, we're going to jump on in, see what we can get as far as clues on what's going to happen. But also, I want you to really pay attention to Judge Sisco in this hearing because there's a lot of denials. And I was saying it to you guys, like if I'm a defense attorney, the first thing I'm questioning is, hey, this judge was just removed from the Alicia Andrews case. I don't want her on mine. Like what? Why didn't they, why not? Why not look at that from that perspective? However, she does need to do something to the defendants for them to file for an appeal, right? They just started, right? So let's pay attention to how she rules on some of these things. If some evidence is going to be suppressed, all of that stuff, okay? So we got a nice view of Davion, who we are seeing having a separate trial from the 4. So let's see what we can catch up on here. Audio's already boosted, captions are on. Y'all kick back, relax, and let's get into it.
I have communicated several times in the last few days, so I can go quickly as to the motion in limine regarding penalty phase, regarding a lingering doubt. I have no objection to that.
Okay,
I cannot argue that. However, I did want to point out that certainly that does not mean that I cannot tell the jury that despite all the weighing of aggravating and mitigating circumstances, they ultimately can vote to what they believe is the correct thing to do. But
And we're talking about, just for the record, so it's clear, the state's first penalty phase motion for order in limine, right?
Yes, ma'am.
Okay, I just want to make sure, because there were a number of states' motions. So, correct. That doesn't impede your right to argue the balancing of aggravating and mitigating evidence. It just means no one can get it. Once, if the jury finds the defendants guilty of capital murder, then during the penalty phase, the parties may not relitigate that.
I agree.
Okay. All right. So I will, as to Mr. Rashad Murphy, that motion will be granted. Okay.
As to the state's second penalty motion, we do not object. I would not get into anything dealing with the details of the actual method of execution.
Okay. So as to Rashad Murphy, that's granted. State's third penalty phase motion.
The third one, Your Honor, the same, no objection. I would not be getting into religious beliefs.
Okay. All right. As to Rashad Murphy, grant the state's third penalty phase motion for order in limine.
As to number 4, and tell me if I'm going too fast.
No.
A description of death on television shows, etc. I no objection to that.
Okay. As to Rashad Murphy, be granted.
As to number the 5th motion, I would not intend to, and this is something that I know the state's going to object because Mr. Harmon already told me he would, but I would not plan to get into details of other types of cases, such as mentioned Charles Manson, Ted Bundy, etc. However, when the state files a motion seeking or a notice seeking the death penalty, they are in effect telling the jury that they believe that this case qualifies as the worst of the worst because it deserves the death penalty. And I think that opens the door for me to be able to argue that this is not the worst of the worst if in fact we were in that situation. And I should be able to talk about comparing it to other capital cases to the extent that the death penalty in this case does not mean worst of the worst. I should be able to talk about torture and serial killing and things of that nature because I would need to separate the facts of this case from other cases that I would argue would be the worst of the worst.
So are you talking about just making a general argument at penalty phase as opposed to saying things like, this is not Granville Ritchie, where a 9-year-old girl was raped and murdered. This is not Angel Kuzchuk, where a 4-year-old girl was stabbed to death. Is that what you're talking about?
Yes, ma'am. I wouldn't be even mentioning other names, but I think that if the facts of this case do not have torture, if the facts of this case do not say serial killing, I should be able to make those distinctions.
Sure. Just generally speaking,
Generally
that this is not the worst of the worst that would warrant a sentence of death, right?
Yes, ma'am.
Any objection to that? Just that general argument at penalty phase, assuming we get there.
Judge, I do object to that. If you look at the state's motion, and I cite the Rocket v. Ohio, Rocket holds that not only the sentences in other cases, but the circumstances of other cases, which would include torture or serial killers. There are many types of serial killers. There are many types of circumstances. There was a Timothy McVeigh bombing in Oklahoma that killed over 100 people. There was Al Donaldson, who recently killed 4 people here in Seminole Heights in Tampa. Ted Bundy, Oscar Ray Bolin, who was responsible for 3 young women here in the Tampa Bay area. They're all different. They're all distinct. All the defendants were of different ages. They have different circumstances. To simply say this isn't torture or this isn't a serial killer, it's even worse because you're leaving it up to the imagination of the jurors. And that's not what they're supposed to be doing. They're supposed to be assessing and conducting an individualized sentencing proceeding for this defendant to give him his due process rights. They're not supposed to be speculating about other cases and the relative proportional culpability or whether this is the worst of the worst or the least mitigated. That term is dicta from U.S. and Florida Supreme Court cases. That's not in the jury instructions. That's not for the jury's consideration. So we would object to that, Your Honor.
And my response, Your Honor, is in the end, they're instructed about weighing aggravating factors versus mitigating circumstances. But in the end, they have to decide what they feel is appropriate. And what I'm proposing, I would submit is a valid argument. And it would be in a general term. It wouldn't be trying to identify specific cases.
Okay. So as the state's motion is drafted, specifically the state requests that the defense not be able, during penalty phase, be able to discuss actual sentences in unrelated cases. So as to just the strict wording of the motion, it's granted. However, that does not preclude any of the defendants from arguing that the facts of this case, combined with their own mitigators, that does not rise to the level of worst of the worst, mandating the imposition of the death sentence. So generally speaking, you can argue that why it is your client should not be sentenced to death.
Thank you, Your Honor. As to the 6 penalty phase motion, I would have no objection. Would not talk to the jury about prior statutes regarding the death penalty.
Okay, so
So,
not
Your Honor,
objection.
as to the state's fifth motion, you're granting the motion as to the defense comparing or regarding the facts or sentences of other specific.
Correct.
Okay.
So there's not going to be specificity, but generally speaking, all of the defendants, if we get there, will be able to argue, generally speaking, why the death penalty is not appropriate for their particular circumstance. Okay, moving on, then grant the state's 6th motion for order in limine during penalty phase.
And Your Honor, the state also filed in each of the defendant's cases a motion to compel the defendant to provide penalty phase witnesses and evidence.
Right, and I issued an order setting a deadline for that. Has
That was met.
So the motion is granted, and Mr. Hernandez has indicated that he has complied with all deadlines established by the court for Mr. Murphy.
Thank you.
Okay, you guys remember this prosecutor, right? He's back. He is back. We also see the redhead prosecutor as well. I did put a poll up, so they're talking about the death penalty, and this is in regards to Rashad Murphy. Remember, we have 3 death penalties, and it looks like it's going to go towards Rashad, it's going to go towards Isaiah Chance, and it is also going to go towards Sean Gathright. The poll reads, is the death penalty too harsh? Your options are yes, no, and option 3 is for the shooter only. So I'm going to keep that poll up for the duration of this hearing. Y'all vote it up, chat. Make sure you hit the like button on your way in. Let's get back on into it.
I think the language of my response was that I reserve the right to be able to make amendments if so needed, but I don't have it in front of me, but I can tell the court that it was timely responded to.
Judge, I believe that did the court's order anticipate witnesses and expert witnesses penalty phase?
I believe it did. Let me pull it up.
And
That's my understanding.
we did provide that.
Okay. So the state's motion to compel also contemplates in paragraph 4 reciprocal discovery as far as records, because I find typically in these cases, as we're.
My bad, y'all. I keep calling them brothers. They're cousins. That has been verified. They are cousins. My bad.
Progressing through guilt phase, at some point, the state's provided thousands of pages of records. That puts us in a very untenable position to allow our experts to have time to digest that information before they conduct evaluations of the defendant. That's the type of information I'm asking for also in the motion to compel.
Right, and in my scheduling order, I gave a deadline for the defendants to all identify any expert witnesses that they intend to call at penalty phase, including the provision of any and all supporting reports, documentation, anything that the experts relied upon.
Our doctor has been listed. He has not provided a report yet. In fact, I think he wants to see him one more time. And Mr. Harmon and I have talked about scheduling his deposition later this month.
Okay, well, I granted the motion. So there's an ongoing obligation for defense counsel to provide reciprocal discovery.
You know, I have 14 motions that I think I can go quickly through if the court would allow me, because I have them numbered a certain way. The first one is motion to declare sections 921.141 and or 921.141 subsection subsection 6, subsection H, Florida statutes. It's basically the hack motion.
Okay.
We're declaring that be declared unconstitutional facially and as applied, and I would rely on my memorandum of law.
Okay, that's fine. And just so, Mr. Hernandez, it will make my life simpler. When I was given a list of the pending motions by the state, and they were broken down as far as numbers and when we were going to hear them. So I have them broken down by the dates that we originally scheduled to hear the motion. So for example, it would be helpful to me, I'm looking at the motions that were initially scheduled to be heard February 26th. And as to Rashad Murphy, the motion to preclude the imposition of the death penalty.
I have them numbered my way. I didn't have them, but I can get to whichever one you want to get to.
Okay.
Which one is it?
It's the motion to preclude the imposition of the death penalty, and specifically that the retroactive application of a death penalty statute enacted in 2016 or 2017 violates Article 10, Section 9 of the Florida Constitution.
Judge, I guess I am having difficulty finding it.
Okay. All right. Okay. So hold on. Let's do this. Murphy. I'm going to pull out all of Mr. Rashad Murphy's motions that I have, and we'll go through those.
I apologize.
That's all right.
I did not have your numbering, and I just numbered them
worries.
separately myself.
She's already on her bullshit.
Heinous, atrocious, or cruel aggravated motion that I just referred to.
All right. Give me just a moment.
She sounds annoyed.
And Your Honor, before I forget, I would request to move orally to adopt any death penalty motions that were filed by co-defendants.
Okay, granted. We have about 60 motions, so just give me a moment.
She is so mad at the disorganization.
Okay, I think I have pulled out all of the penalty phase motions that were filed on behalf of Mr. Rashad Murphy. So tell me, Mr. Hernandez, which one do you want to start off with again?
The first one that I mentioned, Your Honor, was a motion to declare. It's the heinous, atrocious, or cruel aggravator motion, asking that those sections of the Florida statute be declared unconstitutional.
What's the actual?
facially
Oh,
as
here it is.
applied.
Okay, just making sure. So you're arguing motion to declare sections 921.141 and or 921.141 6H Florida statutes heinous, atrocious, or cruel aggravator and or the current 6H interim instruction unconstitutional facially and as applied. Correct?
Your Honor, and I'm relying on my memorandum of law that I've attached, so I don't have any further argument.
Okay, and state, you filed a response to that as well?
We did, Your Honor.
You're relying upon that?
Yes, sir.
Okay, I will deny the motion. Okay, what's
Your Honor,
next?
the next one on my list is titled Motion in Limine for Including Improper Penalty Phase Argument. And Mr. Harmon has indicated that he does not object to it.
Okay,
Yeah, no objection, Your Honor. We won't want to make any arguments in that.
okay, that motion is granted.
Your Honor, number 3, I have motion in limine regarding reference to non-enumerated mitigating circumstances, and I believe the state does not object.
We do not object to that.
Okay, that one is granted.
Your Honor, my next one is number 4 is motion to allow testimony of the impact of defendant's execution on family members. The state, I believe, objects to this one. I think they object to the rest of mine. My argument, Your Honor, to this is the fact that mitigation can be anything. And the fact that he's greatly loved by family members should be something that I should be able to present to the jury. And I would rely on the Lugo case that's in the motion 845 Southern 2nd 74. It's a Florida Supreme Court case, 2003.
Okay, Mr. Hartman.
Your Honor, we filed a written response objecting to this. I can make additional argument for wishes, but
Well, what is it specifically, Mr. Harmon, are you concerned? I mean, you would concede that obviously the defendant can call witnesses to testify as to the why it is that Rashad Murphy should not be executed, and that, you know, if he's a good brother or son or provider or whatever it may be, right?
I do.
And so, but I guess where we're having an issue is whether or not those same family members would be able to testify as to their feelings should Mr. Rashad Murphy be executed, correct?
The impact of the defendant's execution, this is a future event that has not occurred. We don't know when it will occur. We don't know if the defendant would even ever be executed, or if he would die naturally in the Florida State Prison. We don't know if the family members would still be alive when he was executed. It is such an unknowable fact for them to testify about. We believe that's improper. I have no objection to family members taking the stand to express to the jury why they believe his life should be spared.
Okay. Let me look at Lugo, and I'm going to take that one under advisement. So,
Yes, Your Honor.
okay, let you know.
Your Honor, the next one is titled Motion to Declare Florida's Death Penalty Unconstitutional. And in parentheses, it states unreliability. We believe that the argument, Your Honor, is that the fact-finding process cannot be deemed sufficiently reliable to justify imposition of the death penalty. And I would rely on the cases that are cited.
And just to make sure I'm on the same page, motion to declare Florida's death penalty unconstitutional as to unreliability. That's the motion
Yes,
we're
ma'am.
discussing. Okay, and state you filed a reply, which I have reviewed. Anything further?
No, Your Honor.
Okay, I will deny that motion.
She's on a denial streak.
Okay,
Your Honor, the next one is the it reads motion to declare sections 921, 141, 6I Florida statute. It's the cold, calculated, and premeditated motion. I'm relying on the memorandum law that I've listed. I'm arguing that the statute is unconstitutionally vague, overbroad, and it is applied in an arbitrary and capricious manner in violation of the 5th, 6th, 8th, and 14th Amendment to the U.S. Constitution, as well as Article 1, Sections 2, 9, and 16 of the Florida Constitution. And I would rely on the cases that are included in the motion.
okay, state filed a reply, which I have reviewed. Anything further?
No, Your Honor.
Okay, I will deny the motion.
The next one, Your Honor, is titled Motion to Declare Sections 921, 141, subsection 8 of the Constitution unconstitutional as requested for proffer of impact testimony and pretrial ruling on whether the danger of unfair prejudice of that evidence outweighs probative value and or otherwise denies a fair sentencing proceeding. I'm objecting to the use of victim impact evidence.
All right, and state you filed a response.
Yes, Your Honor.
Okay.
We rely upon that.
So,
All right. So she's going through, right now, we're going through all of Rashad's motions. That's Isaiah that's on the camera right now. But Rashad had 14 motions, and he might be tried with the other two boys. And right now they're fighting either for a severance or to have separate juries, which is crazy. I mean, you have 12 people, like they're going to get 12 people. All right. But if they're tried together, do each of them get their own juries, or are they going to be severed out? Now we're starting with Rashad for this hearing, right? So Rashad has 14 motions. A bulk of them that were just covered are things that would happen if he gets sentenced, right? Or things that would happen during sentencing. All of this is preliminary stuff before the trial begins, so we don't have to deal with it later, right? So in Florida is one of the states in the United States that has the death penalty as capital punishment, right? You know, if you're on trial for murder, the death penalty is on the table. There are 3 of them here. So at first, you guys were in the chat. Like, I thought all 4 of them were facing the death penalty. It is confirmed that 3 of them are facing it. If you missed at the start of the stream, I did check out Davion's case file, and it looks like he's getting a separate trial for some reason. I don't know why. So that's probably why, because he's not facing the same level of punishment that the other 3 are facing. There is a poll in the chat right now, but if you're just coming on in, we're going through all of Rashad's motions. His lawyer is, basically saying, hey, I have 14. She is making her decisions right now on most of them. I think there's one of them that she wants to take under advisement, but they're really surrounded around sentencing and, what happens at that sentencing hearing. Usually if a trial happens, the jury reaches their verdict, the next part of the process is sentencing. But, they're talking about some of the logistics, like, okay, well, what if he just gets life instead, right? So if he does get life, will these family members at the time of, when it's time for the death penalty, if they're allowed to speak, if they're even alive, like all of those things is what we're talking about. Let's go back on in.
I will deny the motion. as far as it's phrased that the statute is unconstitutional, obviously the case law controls how victim impact evidence actually comes in, which we will comply with. But just as to this motion that it's unconstitutional, the provision of victim impact evidence, I will deny that motion.
Thank you, Your Honor. The next one, which is my number 8, motion to declare sections 921.141 and or 921.141(6)(b) of the Florida statutes and to be declared unconstitutional. It's basically the argument in this motion is the prior violent felony aggravating factor of this section should be declared unconstitutional as vague and overbroad and has been applied arbitrarily and in an inconsistent manner, and I would rely on the cases cited.
Okay. Anything further from the state?
No, Your Honor.
Okay, I'll deny the motion. All right, next up.
Number 9 is a motion to exclude evidence or argument designed to create sympathy for the deceased. I think I believe Mr. Harmon can correct me if I'm wrong. He agrees to paragraphs 1 through 4. I will not be, or that he would not be arguing the victim impact for the purpose of seeking sympathy for the deceased or in support of any aggravating factor.
Okay, Mr. Harmon, anything further?
Your Honor, we agree to paragraph 1 through 4 of the defendant's motion. The evidence designed to create sympathy for the deceased is inadmissible in the guilt innocence phase, and we certainly don't intend on getting into any type of sympathy evidence or argument in the guilt phase. Paragraph 5, we disagree with. The admission of evidence concerning the deceased or the circumstances is inadmissible under Florida law penalty phase. Well, that's clearly law. Circumstances of the case to support multiple aggravators in this case will be argued in penalty phase. Evidence concerning the deceased would be victim impact. However, Mr. Hernandez did state as to what I told him that we would not argue victim impact is supporting the aggravating factor. So.
That's correct.
Okay. All right. Anything further?
No, Your Honor.
All right. So as to this particular motion, the motion is granted as to items in the motion identified in numbered paragraphs 1, 2, 3, and 4, and it's denied as to paragraph 5. Again, the state is entitled to present victim impact evidence in conformity with the case law.
Your Honor, yes, number 10, there's some repetition here, but it's a motion to limit victim impact evidence. And A through F are the very paragraph or the areas that we're asking for limitations, and we would rely on the case law that's in the motion.
Okay, state what you're.
I'm sorry, Your Honor. What is it?
We're on motion to limit victim impact evidence, and specifically, they're requesting only one witness may testify. The witness must be an adult. The state must proffer a proposed victim impact statement in writing. The court must hold a hearing on the admissibility of the evidence prior to its admission, and the court must consider relevant case law. The testimony must be limited to the prepared statement. No witness may testify if the witness is unable to control his or her emotions.
So, Judge, we object to the remainder of the motion, including that portion. Limits on victim impact of one witness, that's not supported in the case law. There are cases where up to 12 witnesses have been allowed, 12 impact witnesses, even more in some cases. In this case, I'm not sure how many we would call. I know the court is aware we normally try to proffer impact through written statements by the family members. But there have been cases, I have presented impact statements in the past from the community to include friends, family, in-laws, things like that. So I don't believe that these limitations are.
Okay, so you object to only one witness, correct?
I do, and I object to limiting age, that type of thing.
So you object to the witness must be an adult?
I've never called anyone other than an adult in impact. I don't believe in this case that's an issue.
Okay. What about the state must proffer a proposed victim impact statement in writing?
We normally do.
Okay, so what they're talking about is the victim impact statement. So in the event that Rashad is found guilty of murdering Julio Foolio and he is sentenced to death at the sentencing hearing, typically they will allow people, family members, to come up and talk about, the person that's either going to be sentenced to death or the victim. In this case, that means Foolio and his family, right? So what they're proposing is they only want one person to be able to provide that victim impact statement. And what the prosecution is saying is that they've done as many as 12. And I mean, Fulio deserves more than one. Let's just say that, so I'm happy that the prosecution in this, at least in this argument, is kind of fighting to have more than one person talk about Fulio, his life, his, why these people should be sentenced to death for murdering him, or at least life, or whatever the case may be. Because what that is persuading the judge for her to make a decision on what the penalty should be, right? So prosecution is fighting for that, but this is just, it's happening on Rashad's portion of the hearing, but it goes to all of the defendants.
Do that, just I believe it works better that way.
Okay.
The pretrial rulings on the admissibility, so I have no objection to that, I guess.
Okay, the testimony must be limited to the prepared statement, right?
Yes.
Okay.
Yes.
And you agree no witness, either for the state or the defense in penalty phase can testify if they cannot control their emotions,
I
right?
do agree.
Okay. So as to Rashad Murphy's motion to limit victim impact evidence, it is denied as to paragraph A, and that only one witness may testify. However, if we get to penalty phase, Mr. Hernandez, if you want to renew an objection, if the state you think is intending to call too many witnesses for victim impact, then you can renew your objection at that point in time, once we get down to the actual evidence that's coming in. But generally speaking, paragraph A is denied. At this point, I'm going to grant paragraph B, that the witness must be an adult. Again, if for some reason we actually get to penalty phase and the state intends to call a minor, we just need to talk about it before you do it, Mr. Harmon.
Yes, Your Honor.
C, the state must proffer a proposed victim impact statement in writing. That's granted, and that victim impact statement needs to be provided at least 24 hours before the witness testifies. So that way, if there's a problem, we can discuss it. All right. I will agree to hold a hearing on the admissibility of the evidence if there's a dispute. Okay, so that's granted. Paragraph D. E, the court must consider relevant case law. I concur, I must, so that's granted. And the testimony must be limited to the prepared statement. That's granted, that's paragraph F. And paragraph G, no witness may testify if the witness is unable to control his or her emotions, so that's granted. Okay.
Your Honor, the next one, number 11, is a motion to preclude application of the most recent amendments to Florida Statute 921.141. In this case, such application would violate Florida Statute 775.022, where our position is, Your Honor, that for the death penalty to be imposed, there should be a unanimous 12-0, and as opposed to an 8-4.
Okay, state you filed a response. You relying upon that?
Yes, Your Honor.
All right, I will deny the motion.
Your Honor, number 12 is motion to preclude imposition of capital punishment on the ground that the death penalty is presently administered as per se cruel and unusual punishment. And I would rely on the memorandum of law that is attached.
Okay, and state, let's see, you filed a response. You relying upon that?
Yes, Your Honor.
Okay, I'll deny the motion.
The next one, Your Honor, number 13, is a motion to preclude the imposition of the death penalty. And again, I would rely on the memorandum of law that is attached.
All right, state you filed a response. Are you relying upon that?
Yes, Your Honor.
Okay, deny the motion.
Damn, Rashad.
And then finally, Your Honor, a request for a jury instruction. It is our position that in order for an aggravating factor to be considered by a jury, it should be beyond all doubt, not just reasonable doubt. And we're asking for that jury instruction, and I would rely on the case law submitted.
Okay, state you filed a response. You relying upon that?
Yes.
Okay, I will deny the motion. That's all I have for you, Mr. Hernandez, for Rashad Murphy. Is that all you have?
Yes, Your Honor. Thank you. That's all I have.
Okay, very good. Okay, so let's go back to Mr. Gathrights' motion to suppress. Mr. Wise.
All right, Sean's up next.
Your Honor, which would you like to?
Rashad got a lot of denies.
Tell me.
Well, I have looks like the traffic stop first on the pile, or the, not really traffic stop. This is really a multi-layered
Right.
motion, of course. But this is a motion to suppress all the evidence that comes following the traffic stop of Mr. Gathright. And our first layer is that the stop itself was illegal. Obviously, everyone pretty much recognizes it as a pretextual stop. I recognize, of course, that pretextual stops are legal as long as there's an objectively reasonable basis for the stop. The problem here is that there was not. The two officers who conducted the stop testify that it's based on speed and intent. Now, they clearly have every intention to stop Mr. Gathwright's car. Detective Barry is actually in the criminal apprehension unit, which apparently his main job is to conduct stops like this. Despite all of that, neither one have a dash cam in their car. No one has a radar gun or any kind of way of clocking the speed. They both testify as to the speed, that they estimate the speed, but they've only seen the car for a quarter of a mile, approximately. Neither one of them, even today, can testify as to what the speed was on the road where they conducted the stop. They said 35 to 45, but neither one of them even knows what the speed was. And just the same, neither one of them knows what they thought Mr. Gathwright was going at the time. So under the circumstances, Your Honor, particularly given that this was a plan all along to make the stop, this is not an objective, reasonable basis for the stop. And even though
This is an interesting argument. So now we have Sean's lawyer up, okay? So we went through all of Rashad's. We're all done with Rashad's for the day. For those that are coming in, and I'll put it in the chat, this is a recording from Tuesday's hearing. Because Law and Crime is covering other trials right now, they did not run this live. That's why we're watching it right now. And there's actually a hearing taking place on this case today. So likely because Law and Crime is putting it up 2 days later, we will get that probably on Sunday. And if that comes up on Sunday, then we'll go live then so everybody is brought up to speed. But coming back to this argument, one of the key arguments that Sean is using is how he was arrested for the murder, right? If you guys were watching with me on Tuesday, we heard from all of the detectives, the lead detective in Tampa, the lead detectives in Jacksonville, and how Sean was apprehended. Now they're talking about the stop. This is when he was stopped and pulled over and arrested in the gold 4Runner. That 4Runner, I believe, was registered to the grandma, and they found a backpack in that 4Runner. There was a gun in the middle of the console. I think there was a middle console where they found a gun, and then they found some crazy type of drugs. I forgot what type of drugs they were, but they found some drugs as well. It was a pretextual stop, which technically is a little bit out of what you see in the norm, and that's what the lawyer is arguing about. It's like there's a concept in the law called fruit of the poisonous tree. Meaning if the stop was done improperly, whatever evidence that you have obtained from that stop now becomes tainted fruit. Okay, so that's the argument that he's using. Let's see how it shakes out. And again, Judge Sisco is on one, so I want to see if she denies this one, because this is a pretty big motion for Sean.
estimating speed can be a basis under Florida law. The Allen case that I discussed in the memorandum says the estimate has to be reasonable and credible. And in this case, under these circumstances, it's not a credible estimation of the stop. The second basis for the stop, the 10th violation, is also not an objectively reasonable basis. And I have a couple of statutes I had not cited in the memorandum, but I can provide. If you'd like me first, I can cite them.
Sure.
But it's really just two traffic statutes that pertain to 10th violation.
And for the record, you've handed me 316.2954 and 316.2951.
Yes, sir. And here, again, at least Officer Bear, I can't recall if
Speaking of stops, we got to stop the show whenever somebody comes through and drops a hundo like this. Y'all give it up for the Little Gaming Channel. Seriously. Shout out to the Little Gaming Channel who's sponsoring your stream today. We have been very busy over here on Team AV7. And yes, I'm doing my makeup. It's a nice little joke because Alicia Andrews is the only defendant in history that has done her makeup on camera during a trial. It's crazy. It's crazy. I mean, although you do see like Courtney Clenny sticking out her tongue in court proceedings too. So that's going to be another crazy trial coming up. But what does the Little Gaming Channel say? If y'all could do me a favor, please type TLGC in the chat. He is sponsoring today's stream. He says, you should stop with the makeup, AV. It's impossible to get more beautiful. Aw, thank you. He says, I caught a live. I'm here for the foolishness. Yes, guys, it's going to be very busy in the next few weeks. I was keeping my day open and next week open because Nathan Wade is scheduled to testify in the Georgia election interference case. If you guys watched Fani Willis testify with me in December, that was crazy. Nathan is scheduled to testify any day now. So I'm waiting to keep it open. That's why we're kind of streaming the Foolio stuff too, because Next week is going to be impossible. April, we got Courtney Clenny, and it looks like we'll have Davion. And then in May, we got these boys, and they are scheduled to go to trial together. But thank you so much, you guys, for shouting out TLGC. Y'all also follow him. He has a channel. And you know, he plays video games. Like, watch him, check him out. Like, it's not just a little gaming channel. That's not just a username. He actually has a channel. Y'all check him out. But thank you so much, TLGC. I hope you are doing well out there in Cali. Let us go back on in, guys, and see if Sean wins this critical motion.
If Detective Griffin claims he sees a 10 violation as well, I think he may have. But neither one of them end up measuring the car. Someone else does. They don't know what the reading was. But in any event, Detective Barry issues a citation for a tent violation at some point. But he issues it, as he testified, for the tent being less than 15%. The problem with that, Your Honor, looking at 316.2954, it states for most cars, I guess you could say, that is the law. If it's less than 15% in the visible range, that's a tent violation. And that's what apparently Detective Barry relied on. But it makes an exception for what are clearly SUVs, and the officers testified, and I think everyone knows a 4Runner is an SUV, but one of them testified to that fact, that something that qualifies as a multi-purpose passenger vehicle is allowed to have rear windows that have a light transmittance of at least 6%. So substantially lower threshold than the 15% that's most applicable. And then looking at the other statute, 316.2951, it defines what a multi-purpose passenger vehicle is. And I think that clearly is a sport utility vehicle.
Well, it says 10 persons or fewer.
Yes.
Does that include
The way I interpret it, Your Honor, it can be, it's 10 or fewer if it's constructed on either a truck chassis or has special features for occasional off-road operation. The statutes do not, as I see, define sport utility vehicle. I think that definition clearly would encompass a sport utility vehicle.
a 4Runner, a Toyota 4Runner can carry 10 people legally?
Well, 10 or fewer. I don't think that it has to be, if it were 10 or more, I think that'd be problematic. But it's 10 or fewer, constructed on either a truck chassis or for special features for occasional off-road operation.
Okay.
So in any event, I think that encompasses what a 4Runner would be, and that pertains to when you read in conjunction with 316.2954, it allows for tent to be 6% or higher. So clearly, I think the officers, well, I quite frankly think it was a pretext. It was a case of stop the car and figure out a reason later. But in any event, it wasn't objectively reasonable because I believe they were relying on the wrong statute regarding the tent violation. Next layer, though, would be the search of the car. And I believe there really are two issues with regards to the search. Number one, Detective Griffin is the only one who allegedly smells the scent of marijuana. I don't believe that his testimony in that regard is credible at all, based on what you saw last week. So he stops the car, is talking to Mr. Gathright at the car window for quite some time. Detective Barry also comes to the car window to get the license. Detective Barry never smells marijuana. Detective Griffin, after some time talking with Mr. Gathright, claims to have smelled the scent of marijuana. He says in his own words, it was a faint smell. You can't distinguish between whether it's fresh or burned, but he claims he smells marijuana. When the car is actually searched, there is a small amount of residue in a sealed mason jar. The quantity is too low to even be able to try to weigh it. There's no presumptive test performed on it, probably because it's of the small amount. It's in a sealed mason jar in a sealed backpack inside the car. There's no way that could be giving off any kind of odor of marijuana to be detectable from outside the car. And there's no indication, he testified he doesn't see any signs of impairment on Mr. Gathright. You can't say that it's a smell of burned marijuana that might have taken place, you know, if someone smokes in the.
Oh, for people that, you know, dabble with weed, right? If it is in a mason jar, in a backpack, in the back seat, or in the trunk, can you still smell it? That's what he's arguing right now, is one detective said that he smelled it and that was a part of the stop. And the other is saying that they didn't and that they pulled him over because of the tint or whatever the case may be. Can you still smell it? Put a 1 in the chat if you think you can still smell the odor of marijuana. Put a 2 in the chat if you're like, if it was in a backpack in a sealed mason jar, can you smell it? If you're like, no, I don't think so, put a 2 in the chat. I'm curious. We'll do a quick social poll to see what y'all think. I'm seeing some yeses. Y'all are like, yeah, you could smell it.
Or sometime earlier in the drives, he says it's a faint smell of marijuana. The facts just don't support his claim that he smells that from outside the car. But number two, even if he did, the law has changed considerably in the last several years. And the Williams case in particular that was issued back in the fall recognizes that there are numerous forms of marijuana or of the cannabis plant that are legal to possess under state law and federal law. Anything basically that qualifies as hemp under state or federal law looks like illegal marijuana, smells just like it, and no one can determine which it might be just based on the smell. Aside from that, of course, under state law, medical marijuana can be lawful in certain circumstances. And for a time, it appears this Delta 9 marijuana was lawful to possess. But in any event, the hemp is lawful under both federal and state law, and no one can really distinguish between the two. And that's why the Williams case has now held, similar to Baxter in the 5th District, I think the year before, that the odor alone is not enough to support stopping. Now, what happened in Williams, and I'm sure the state's going to argue that, is that in Williams, they found that even though that's the law now, when the search was conducted, we had a different precedent. So they said that the officers acting on good faith reliance could do that. Here, the problem again, aside, just for the record, I would argue, saying that good faith reliance is okay really doesn't make a lot of sense in this situation because the laws that the DCA has recognized changed, happened long before this search was conducted. So I don't believe that it actually is reasonable to say officers should have been able to rely on prior precedent when the laws that legalize forms of marijuana were in existence. But the other problem in this particular situation is I don't believe officers were acting in good faith. We know very well they were looking for any reason to conduct a search of that car. I would suggest to you this is a classic case of we'll search first and we'll figure out justification later. I guess you could say luckily, but there was some little form of marijuana found in the car that they could rely on. But clearly, under the totality of the circumstances, this search is being conducted because they want to find evidence from this case and they're going to find a reason later. And they find a little bit of residue to justify it. It's not good faith reliance on prior case law. The next level, Your Honor, of this motion is assuming hypothetically that the smell of marijuana would give the reason to search the car. Law enforcement goes far beyond searching for potential marijuana and more importantly, in what they seize from the car. Law enforcement seizes these casings from the car. They're not unlawful to possess, just like the rifles. Now, there's a claim that handguns cannot be possessed because of Mr. Gathride's age, but there's no prohibition on possessing fired casings. There's no prohibition on, even if they're for a handgun, there's no prohibition on rifles. There's certainly nothing illegal about the laptop and iPads he possessed, but all of that is seized from the car based solely on this sense of marijuana. And we know very well why everything was seized, but there has to be an objective reason to do it, and there wasn't, especially for fired casings. I mean, he's not a convicted felon. There's no reason he couldn't possess those to begin with. The last layer of the search, or of the motion rather, is all of this evidence is then used to get the search warrant for Mr. Gathride's house. I think everyone who testified about that agreed that search warrant would never be sought, even. It certainly would not have been approved, but for the evidence that's found in the car. I recognize, and I'm sure the state will point out, that search is being conducted by Jacksonville officers regarding really, it would appear, I don't even think it was the earlier Charles Jones shooting. It was another shooting they linked to the casings that were found. But what's significant is they still seize substantial evidence that they're trying to use now in this case. And that would never have happened but for the illegalities that occurred during the traffic stop. And I believe even though it's conducted by Jacksonville and the warrant is sought in connection with a different case, it's clearly a fruit of poisonous tree because but for the illegal stop, the illegal searches, there would never been a search of the house. I believe those cover all of the bases that I'd be relying on for this motion.
Okay,
And you mentioned, and I just want to make sure we're on the same page, you concede that the second DCA at Williams, they actually affirmed the trial court finding specifically that the law in our district at the time of Mr. Williams' arrest and Owens was the law in the second DCA at the time of Mr. Williams' arrest, and it expressly permitted the search based solely on the odor of cannabis. Thus, by following Owens, law enforcement was acting in objectively reasonable reliance on finding appellate precedent. We therefore affirm.
I certainly agree that that's what the second DCA.
Okay, and that the arrest in this case and the search of Mr. Gathride's car occurred prior to the Williams opinion being issued, correct?
That's correct.
Okay, Ms. Wise, thank you.
You gonna rule on it?
And Your Honor, the state is relying on Williams v. Florida, that second DCA case as well. It is clear that there was a objective legal basis to stop that Toyota 4Runner in Jacksonville. You heard from two law enforcement officers from Jacksonville who were in separate vehicles, who both are trained and certified in estimating the speed of a vehicle. They both obtained that week-long class where they were able to demonstrate that they were able to accurately estimate vehicles within 5 miles, tested upon tested against a radar gun. They both had that training. They both passed that training. And with regards to Detective Griffin, he says that he still utilizes that training and makes that type of estimation 1 or 2 times a week as part of his duties in his present job. And they both estimated that the defendant was speeding. They chose to just give him a warning in that instance, so that there were 2 bases to believe that the defendant should be stopped. The other one was that tint, and you heard that he was actually given a citation for that based on another detective coming out there, they actually came and they measured the tint, and that was within the range that was not valid, so that he was issued a traffic citation stop based on the illegal tint that SUV had at the time. So there was a reasonable basis to do that. And you heard from Detective Griffin that he smelled the faint odor of marijuana when he was standing at that vehicle. Officer Berry had already taken the license at that point and had walked away. And based on a search of the vehicle, based on the smell or odor of marijuana, they indeed found marijuana, which again goes to support that was a credible observation by Detective Griffin, that he actually did smell the marijuana and was able to conduct a legal search of that vehicle. In searching that vehicle, any place where you could find marijuana, he found a handgun. And the defendant was 21, under the age of 21 at the time, and the defendant was arrested for 2 bases, based on possessing the marijuana and drug paraphernalia, as well as a person under the age of 21 possessing a handgun. Those were bases to arrest the defendant and conduct a inventory search of all of the vehicle. And you heard that it is protocol whenever not just a firearm, but any sort of ammunition or parts related to firearms, when they are found in a vehicle, regardless whether it's a search warrant or an inventory search, all of that gets put into NIBIN as part of their procedure. And it is the NIBIN results that lead to the search warrant, a properly executed search warrant of that house in an unrelated homicide investigation, which provides for all of the evidence then that is related in this case. It really does turn on the traffic stop, and there was a reasonable basis for law enforcement to stop that vehicle and then conduct the search that they were able to find all of the other evidence in the case. So, Judge, if there is a reasonable basis to stop, and we rely on the Williams v. Florida case, which was decided in October of 2025, where they said that no longer would you be able to use the smell to justify a search of the vehicle, but good faith reliance on binding precedent at the time, which was October of 2025, they're not going to suppress any evidence based on a search based on smell. And this search happened the year before. So we would ask that as well, Judge, that good faith reliance, that was binding precedent. That was the law at the time of law enforcement was able to conduct a vehicle search of Mr. Gathwright's Toyota SUV based on that odor and smell of marijuana. He went into his credentials, his familiarity with that smell, and that search did in fact lead to marijuana within the vehicle. So based on all of that, we'd ask you to deny the defendant's motion to suppress.
Okay, Ms. Wise, any rebuttal?
Just briefly. With respect, I recognize at least one of the detectives. I think they both talked about this, the class that they take, and they may be qualified at times to make traffic estimations as far as the speed someone's going. But the problem is, it has to be reasonable and credible. That's what the case law says. You can estimate, but it's got to be reasonable and credible, and that's the problem. It's observing for a quarter of a mile. Can't even say what the speed limit is, even to this day. Can't remember how fast they thought Mr. Gathwright was going. So I would suggest, even though maybe they're qualified under some circumstances to make the estimate, we don't have the evidence here to support that, to show that it's reasonable and credible. Again, as to the tent violation, it's measured, but no one last week had even testified what the measurements came out to. And I believe, as I pointed out, I think they're relying on the wrong statute quite clearly when they were reasonably, in their minds, objectively determining that the tent was not lawful. Williams, again, before obviously reaching the point where Williams will come into play, there has to be a finding that the smell, that the testimony you heard was credible, that the officer actually smelled the marijuana. I don't believe that finding can be made given the testimony from last week. But even if it could be, I obviously don't agree with Williams and their conclusion that they should rely on it. But this isn't a situation, even recognizing that holding, where the officers are relying in good faith on Williams. They're trying to find any reason they can to justify the search. And they clearly, obviously, it's a pretextual search. No one's really disputing that. But it makes no sense for them to come back and rely on Williams after finding this little bit of residue. With regards to casings being placed in the NIBIN and the various other firearm evidence being collected, that's a seizure. And I don't believe that there was a lawful basis, given Mr. Gathwright is not a convicted felon, to seize casings from the car and put them in the knife. That goes beyond searching for marijuana. It goes beyond even an inventory search.
Well,
That is a seize.
What's your position on whether or not there was probable cause to arrest Mr. Gathright for the for the gun that was found in his car and he being under the age of 21?
Well, they don't do that, I don't believe.
She's
And
gonna grant it.
under the circumstances, I can't.
She's not
agree that
granted.
That
Sorry.
would give probable cause and to arrest him for that. We don't know. Sorry. To arrest him for that. The car, for what it's worth, is registered in his mother's name. His mother is a retired Marine. The handgun is not in plain sight. It's deeply concealed within the car. So I don't believe there was probable cause for that.
Okay.
Again, even then, the Nibin hits, the last argument I think the state was making, the Nibin hits didn't provide a lawful basis to search the house because there would never been Nibin hits if it weren't for all these illegalities that led to the Nibin hits.
Okay. I understand. Thank you. Okay, I'm going to take it under advisement. I'm going to do a written order. All right. So then we have Mr. Gathwright's motion to suppress evidence illegally obtained from the defendant's iCloud accounts.
Okay, so Sean, that's one of she didn't rule on it right then and there. She said she's going to take it under advisement. I mean, Sean seems a little irritated with that, but I'm going to take a look at his case file again to see if she has put the order out, because this is on Tuesday. So we're just waiting for the judge to make a decision on that one, because a lot of evidence was collected as a result of that traffic stop, right? And I mean, Sean was under the 18 with the gun, under the age of 18 with a gun. He shouldn't have had it. But at the same time, you still got this little ninja on camera, okay? Like just airing out Julio's car. So now he's going to argue another motion about the iCloud account. Now, if you guys remember this, remember the big smoking gun that we saw in Alicia's trial was Sean's mom on the stand saying that no one had access to the safe in her house with the guns, right? No one, even though there were 2 entry points to that safe. There was the trinket box on top of the, dresser with bent back paper clips and missing earring backs, right? There was a key to get into the safe. So that's an entry point. The second entry point was access using a code. So Sean's mom and apparently her ex-husband were the only 2 that had access or knew what the code was. The issue here is there was a text message introduced at Alicia's trial, and they were text messages between Sean and his mom where she gave him a damn code. So they're trying to get this evidence thrown out before his trial starts, okay? So that's why his lawyer is kind of taking this angle of issues with evidence collection and how they went about collecting it from the law enforcement standpoint. I mean, that's a big smoking gun right there. That was the biggest blow up of Alicia's trial, where it's like, your mom just lied. She committed perjury and she was being really, really combative on the stand. Let's go back in and see how he handles this argument for the iCloud evidence suppression and if she takes it under advisement or rules on it from the bench. Let's go in. Okay, looks like we got some freezing action happening here.
So it's a much different motion, obviously, Your Honor. It probably became apparent last week that I was a little surprised by some of Detective Ramos' testimony. That may not have been apparent, but I set out in the motion and I was intending to argue that what I believed was a date range, a temporal limitation in the warrant was overbroad. And from Detective Ramos' deposition, in all fairness to him, he couldn't really remember every search he conducted because he conducted many searches, but it was that if there was a temporal limitation, I would have stayed with him. Clearly, he did not. He testified last week. He had no intention at any point of limiting what he was going to search from the iCloud. And he clearly did not. He searched the entire thing. That's what he testified to last week. That, Judge, I don't even know that it can be questioned that would not violate the particularity requirement of the Fourth Amendment. This is an evolving body of law, but the cases that have addressed this, several 11th Circuit cases, and then I think the Demons case is probably the most on point state of Florida case. They recognize you going in and searching someone's iCloud account is the equivalent of a general warrant. It's just rummaging through basically their life. In this case, it was rummaging through almost 4 years of Mr. Gathwright's life. That's why a lot of this goes back to the McCall case from the 11th Circuit.
All right, I might refresh this because we seem to be getting a lot of problems here. Where
And Demons relies on that, but there have to be temporal limitations on what is being searched when a warrant is being sought for something like an iCloud. in reading the
Demon.
warrant and the affidavit that Detective Ramos drafted,
I'm gonna refresh it. I think he's referring to Melly's case. How ironic. All right, let's go to 54 minutes. I'm just gonna refresh this for us, y'all, because it started to freeze a little bit. Always with technology. It only happens when we're live. I swear to God, it only happens when we're live. Okay, let me go to, we left off at 54 minutes. Here we go.
when he submitted the request, and in the warrant that was actually signed, it basically provided free reign to review the equivalent of everything that was in the iCloud account. All emails, all instant messages, all iCloud data associated with backups, all contacts, all records and information regarding locations, all data stored in location services, all records pertaining to the type of service used, records of games, videos, other remotely accessible data, and the associated IP addresses, all files, keys, basically anything you could think of that could be in an iCloud, he includes in this affidavit and in the warrant that he drafts. Even if that's problematic in itself, even if we have a temporal limitation of a month and a half, but there was no limitation whatsoever. It essentially went back to March of 2021.
Well, didn't he testify that Apple just gave him everything?
They did. And I think in the deposition, that's what he thought happened. And even if that's the case, Apple clearly did give him everything. And it's addressed in a couple of other cases I'll get into. But even if that was the case, then he would have a reason to limit it to whatever dates were in the warrant. So even if arguably this could be read in the warrant as a temporal limitation, which he apparently did not read it as, then he has a duty to confine what he searches to that. And I asked him about how, wouldn't it be easy to just click on the last access date and then organize everything by that date? You can search only things within that date range. But he had no intention of doing that. He looked at the entirety of the life of the account, almost 4 years worth of material, at least 3.5. So even if that was a limitation, and even if Apple ignored it, he made no effort whatsoever to limit what he actually searched. That, Your Honor, I think clearly violates the holdings in Blake, which I think is the probably the main 11th Circuit case that addresses this. In Blake, they addressed two different warrants. There was one to, I think it was Yahoo. There was one that they found was not problematic, although it appears in reading Blake that they were that was even a close call. But then there was a Facebook warrant in Blake that they found far exceeded the particularly requirements of the Fourth Amendment. This one is just like that. It really had no temporal limitations, and it had no categorical limitations. It was what they found to be the equivalent of a general rummaging warrant. I don't know if the state, really can even argue that did not violate the Fourth Amendment, especially the way the warrant was executed. But I think a big issue now that's addressed in the Demons case that I cite is, according to Demons, there can be an attempt to try to, I think, basically parcel out what was unlawful, what went outside the temporal limitations, and focus on what may have been reasonable. They did that in Demons, but they also said that it's not always going to be appropriate and not always going to be feasible. In that case, and unfortunately, Demons, they don't really say, they don't talk about why that warrant was overbroad. It appears the state agreed it was overbroad, but then they made an attempt to limit it to information from the time of a shooting that was being investigated and a few hours before and after. But in reaching that point, they noted, relying on a couple of federal cases from other circuits, one being Gulp and the other being Pilling, which I have a copy of. But they said that even when parts of a warrant may be valid and distinguishable, severance may be appropriate if the sufficiently particularized portion is only a relatively insignificant part of the sweeping search, or where the warrant is generally invalid but has some tangential item that meets the requirements of probable cause. The problem here, Your Honor, is it's far from a relatively insignificant portion of the warrant, whatever might have arguably been relevant, because we have, again, 3.5 years worth of Mr. Gathwright's life that is collected in this iCloud. And really, based on Detective Ramos's testimony, there was no significant limitation that he could establish that might have been lawful. And even if there had been, he completely ignored it and went far outside of whatever limitation it might have been. I had been prepared to argue that June 1st to July 12th was substantially overbroad because it encompassed far more time than this conspiracy could have even arguably existed. And we went back and asked when was this first advertised that there would be a Charles Jones show in Tampa, and that was June 14th. So anything before June 14th could not have impacted this, could not have been evidence of the conspiracy, because there could have been no conspiracy. Nobody knew Charles Jones was going to be coming here until June 14th. The evidence or the facts set out in the affidavit are really pertained to actions that occurred from June 22nd to June 28th. In any event, nothing before June 14th could have been relevant. Yet this goes 2 weeks before that and then goes substantially beyond the time the conspiracy was alleged to have existed. Under the circumstances, Your Honor, and I would provide, I cite to most of the cases I'm relying on, but the one that I didn't cite is Pilling, which I have a copy of. But
Okay.
It's referenced in Demons.
Okay,
It's a district court case from Idaho, so obviously not binding on it, but it's a very, very similar circumstance that they dealt with. And that one, and then Demons, I believe I said, also relies on that. But in that one, basically it's the same thing. They get an entire Apple iCloud dump. Apparently there's some discussion about, there may have been some attempts to purge the information that would have gone outside the relevant limitations, but it states, and this is on, I believe it's the third page of the printout, that the government realized it inadvertently failed to purge the data, and essentially everything ended up being looked at. It appears that was done accidentally. Here it was done intentionally. But in any event, they go forward, find that the warrant was substantially overbroad, just as we have here. And then at the end of the case, the last 2 pages, they discuss why severance can't apply in that situation. And similar to what the court found in Demons, they're saying that you can't sever this because of the relative size of the valid and invalid portions of the warrants. And the portion that might arguably have had some relevance was relatively insignificant given the substantial size of the information that they had. Then they go on to conclude the opinion by finding additionally that the suppression was also justified because the government did not filter any of the unresponsive data before reviewing the defendant's entire iCloud account. And that's exactly what happened here. Even if in Pilling there was some attempt, there was no attempt whatsoever here. As Detective Ramos's testimony established, he had no intention of limiting anything. He was looking at everything that was going to be in that iCloud, and he did so. And I think the substantial portions of what he took out of that he finds to be relevant would have been far outside even the date range in this search warrant, but he didn't confine himself to that in any event. Good faith exception is obviously something that may be brought up. I don't see any way the good faith exception can apply here when the detective drafts a search warrant affidavit that he himself says he has no intention of limiting to any kind of temporal limitation. So even if the court arguably saw this to be a temporal limitation, it was essentially Detective Ramos deceiving the court because he said in his own words he had no intention of limiting what he was going to look at. And then even if the court did, issue what it believed to be a good faith warrant, Detective Ramos had no intention of following the limitation, and he didn't. He went far outside of it. I would suggest, Your Honor, even the date range of 6/1 to 7/12 in light of Blake and the other cases that we rely on, that's a facially deficient warrant. But regardless, Detective Ramos, number one, had no intention of the court limiting it to that date, and he had no intention of abiding by those dates. So I don't see any way the good faith exception could apply.
Okay, thank you, Mr. Wise. Ms. Ismer, why should the state not be limited to the dates of June 1, 2024 through July 12, 2024?
Number one, because the return was accurately complied with by Apple and Detective Ramos, but also because in the months leading up to the incident, several of the items of evidence that were discovered within the time frame that's listed in the original warrant date back to or in some way connected to evidence that's also located on the device in the months before. There were several representations by the defense that Detective Ramos nor Apple abided by the warrant. And I believe there was some insinuation that there was misconduct or an ill intention by Detective Ramos. But if Mr. Wise has read the content of the search warrant, including the probable cause affidavit, what Detective Ramos requested was included in his request were the iCloud backups from both of these accounts from Mr. Gathrights devices. And that is exactly what Apple provided. When he backed up those devices between June 1st and July 12th, the information from the months prior were included in that backup. So yes, that is what was provided to Detective Ramos. There was also the reason for requesting such information also testified to by Detective Ramos, because oftentimes those items are either mislabeled, not labeled, and now with Apple's ability to actually change the date and time on photos and videos in devices, they make requests that specifically cover that type of occurrence happening. So it's not an overbroad warrant, but more specifically, the time frame from before the offense itself has several links to the temporal timeline that was provided of June 1st to July 12th. The specific example that we gave, or at least I asked Detective Ramos about, was in particular a photograph that depicted two separate rifles or assault rifles on the ground. The photograph, as it was discovered in the device of Rashad Murphy, that had been previously discussed, was sent to Rashad Murphy's device from Sean Gathrights' device within the temporal time frame that was listed in the warrant. But that photograph actually originated when you selected it or clicked on it in Mr. Gathrights' device, having been received at a time in March of 2024. And so when you actually open the file and look to created by modified date, you could see the trail of where that photograph came from, and it would certainly be relevant to this case. Neither Apple nor Detective Ramos actually violated what was requested in the search warrant or what was actually disclosed or provided in the data that he received. So in looking through the data or the backup that occurred between the temporal timeframes that were listed in the search warrant, which again is also not overly broad, given what's been stated and the evidence that they had at the time of the premeditation leading up to the offense itself, and then ultimately the flight from and attempt to conceal their identities thereafter, it's an appropriate timeline of evidence that they were seeking. Several of the Jacksonville detectives also testified about their having seen visually several of the defendants or the defendants getting into it with the victim in this case in advance of his homicide. And so having a time frame which spans before the offense itself and thereafter not only provides a full picture of all of the data that's relevant to the case, but also the relationship of that device and if there are changes. Does this device typically stay in Jacksonville? Did it travel to Tampa on this weekend? You're not only establishing direct evidence from the date of the offense itself, but also the pattern activity for that device as well.
Okay, so if I'm understanding you correctly, so the photo of these firearms that was on Mr. Gathrights' phone, it was originally received on his phone in March of 2024?
Yes, March 27th of 2024 from Isaiah Chance's cell phone.
Okay, so Isaiah Chance sends a photo of Mr. Murphy or Mr. Gathright?
Isaiah Chance sends a photo of two firearms on the ground, rifles on the ground, to Sean Gathright.
Okay.
That photo is then sent from Sean Gathrights' device to Rashad Murphy's device in June.
June what?
June 20th of 2024 at 3:02 a.m.
Okay. Okay, and so if I'm
As they're still trying to wiggle out of Sean's phone, y'all do me a favor and hit up the little gaming channel in the chat again. Hits me with another 100. He says the Courtney Claney trial, save the date, April 2026, live right here on AV to the 7th power. Thank you so much, the little gaming channel. He's really supporting me, guys. Like, little gaming channel has been one of those supporters that have watched multiple trials with me, like literally from the beginning. YSL, Julio Foolio. We're going to do Courtney Claney. We're going to watch these boys go to court in May. You know, it is going to be a busy year. We've done the whole Fani Willis, Nathan Wade thing. There's another hearing on that next week, allegedly. But it's been super busy. And when y'all come out you come out the woodwork really supporting hard like this, I really do like to stop the show to acknowledge that. So thank you so much, Little Gaming Channel. I truly appreciate all the support. Even what was it, Karen Reed last year? He was one of the, top supporters for that. So, from the bottom of my heart, TLGC, thank you. But yeah, this is going to be a very busy spring for us. So y'all stay locked in because it's going to be really interesting. But let's go back to this because we're still on the argument of Sean Gaithwright's phone. I have pulled up his case file here, and I have a list of what she's ruled on, what she hasn't ruled on. And y'all keep in mind that they're actually in court today. These defendants they were scheduled to be there at 9 a.m., but it's not being live and televised. This is from Tuesday's hearing. So maybe we'll get some movement today. I mean, he has 2 new documents in his case file. I'm just pulling them up. And after this, I will show them to you guys so we're all on the same page. But y'all type in TLGC in the chat. Let's go back on in.
understanding you correctly, so in the temporal time limit of June 1, 2024 to July 12th of 2024. So the subpoena goes out to Apple and then they send in everything that was on the phone during that time period or that account during that time period, plus any backup. So anything that was backed up during that time frame also gets produced, correct?
Yes, they would not have what's on the physical device. They would only have the backups.
Okay.
Because it wasn't a search warrant for the physical phone itself. Right. Only whatever went to the cloud, right. This, storage location. They would only have, if the device was backed up, whatever that file was and the dates of the backups. So They could only provide or produce backups in the timeline that they were given in the search warrant.
Okay, but that then kind of becomes a dragnet that brings in, even though you're putting a temporal time limit on this application for the warrant, and that's what the judge signs, and that's what the warrant says. Nonetheless, because if the device or if the iCloud accounts are backed up during this temporal time frame, then everything that was in the accounts now gets brought back in. Correct?
Correct.
Okay.
The reason it becomes relevant, Your Honor, is for several points. If a file is deleted or altered in some way, it would not have a time frame linked to it. So that would come with the backup. We would often be able to see it if it's deleted and not overwritten. But if it is, sometimes you can't see the file, or sometimes you can say where it says deleted and can't open it. But those actions are also relevant if files are deleted at or near the time of the offense itself. Sure. Then the files that link back to the prior incidents, if they are linked to the data that's provided to the offense in some way, that photo I'm talking about from device to device between the defendants being one of the relevant examples, that is an argument as it relates to weight and relevance for the defense to make. The fact that we can trace that photo back from before this temporal time frame doesn't make it inadmissible evidence as a result of what was disclosed to us. When you open the file, if created date, modified date, and last access date, because you received the photo of guns 3 months ago, but sent them 3 days before the murder, certainly those are relevant to the case. So selecting that image, just because the data is dated before the time frame included in the warrant, it's also relevant and related directly to the time frame that we have.
Right. I understand why the evidence would be relevant. I understand that argument. I guess the question I have is, if the state has the ability to acquire all of the evidence in someone's iCloud account, because a backup occurred during the time frame, then it kind of makes the time frame meaningless. There is no time frame, because then if the backup occurred, now law enforcement gets everything just by virtue of the fact that the backup occurred during the time frame. And so then, which makes the temporal requirement then really irrelevant.
If the court is presented with those items that the defense seeks to exclude. So had the state presented to you photographs which we could establish based on the electronic data that dates had been changed on to before the offense, or that had been deleted, the court would have to look to those items to determine whether they were within this time frame, whether there was something in those photographs which allowed us to date it, or there was some evidence of them having been modified, which is why we would not exclude all of the evidence, but instead the defense would have to at least specify which items they are indicating are outside of that.
Okay, are you prepared to do that, Mr. Wise? Are you prepared to make the argument that specific items of evidence are outside of the time frame on the subpoena and therefore shouldn't come in?
I certainly would have been, Your Honor. One of the things I asked Detective Ramos came up at his depot was, he claimed there are photos where Mr. Gathright is making what he believes are gang signs. In my review, I don't think any such photos would have been within this time frame. So I asked him again last week, which ones are you talking about? Because I'd like to try to identify. This has almost 14,000 photographs. So it's not something I can do easily, but I've parceled out the ones that I think might have a gang sign. None of them are in that date frame. So short answer is yes, Your Honor. Again, I don't think this is severable. I think the entire thing should be suppressed, but even if
No, I understand.
even if it's limited, yes. I mean, I'm gonna ask the state to establish a basis for every piece of evidence from that iCloud to show that it came from whatever the court finds to be the appropriate date frame.
Yeah, okay.
And, like, I can add my rebuttal, but
Yeah, no, I hear you. And I'm probably asking the wrong person. So shouldn't it be your responsibility to identify what items of evidence, assuming I find the time frame of June 1 through July 12th to be appropriate? Just assume for the sake of argument I do. Wouldn't it be your responsibility then to identify what items of evidence the state would intend to admit at trial? And then I would hear argument on whether or not that would be admissible. Can that be your job to do?
Well, at this time, Your Honor, the state's position is that the items that have been received in the response are admissible items. If the court is limiting the state's date range, then the state would obviously assert that the dates that are provided in the warrant are more than satisfactory based on the probable cause that's stated in the warrant. The issue then becomes the images that can be connected to or dated back to the other evidence in the case. So there are ways that the state can articulately provide those items, meaning we just have an evidence view of those items sooner rather than later. And certainly we can do that as it relates to the iCloud account for Mr. Gathright, if that would be beneficial to Mr. Wise, but nothing about that type of evidence view would change the state's position specifically as it relates to the time frame that's listed.
Okay, all right. Mr. Wise, any rebuttal?
yes, I think
They're fighting to keep his phone in.
I certainly disagree that Detective Ramos and Apple did not violate this warrant. I think Detective Ramos's testimony last week, he more or less admitted. I mean, he did admit. He said this basically auto-populated, and even if that was, which I think it's reasonable to read that as a date limitation. And I think Judge Smith likely did,
Right.
but Detective Ramos sure didn't, because he said himself, he went far outside that. And with respect to the backups, if an account is backed up, it may be relevant to see evidence that it was backed up during that range, but that doesn't just open the door to look at everything that was on the backup. Because if we're doing that, I mean, what's the point of putting any limitations in this warrant?
That's my question.
Right. So I don't see how, again, the fact that it's backed up, sure, that's relevant. If you find that the warrant's severable, but that doesn't open the door to just look at everything in there. And that's what happened. And looking at the hard drive that I have, it doesn't it doesn't distinguish that I can tell, and I'm far from a tech expert, what was the backup and what was not. It gives two accounts, which are the two that are in the warrant. And I don't see how it distinguishes between what was backed up and what wasn't. It's just everything. And that includes almost 14,000 photos, 400 and something live photos. I can't remember how many videos. I believe a few hundred, if I recall. It's his life for 3.5 years.
Yeah,
I'm
no,
not
I hear you.
Exaggerating. One thing I would add, and I recognize if the court finds, some temporal range to be appropriate. I agree that if there's a photo maybe that's older that is sent during that range, that may be lawful under the warrant. But the problem is, and it's very easy, by the way, to do that, as Detective Ramos testified. You've got categories. You can click last access, date created, last modified. You can sort them all that way. It takes a long time because of the data for it to populate, but it's as simple as clicking a button. So it's pretty easy, I believe, to determine what would have been at least accessed during that range. But that doesn't open the door to going down trails that take it far outside. I mean, if a photo is from 2021 and it's sent during, June 24th of 2024, and the court finds that appropriate, I agree that would be within the range, but you can't keep going down rabbit holes and going far outside the range. And I think that's the problem. One thing I would point out, because I know it was brought up that, there may have been something that Jacksonville detectives knew. Obviously, the search warrant affidavit is confined to what's in the four corners of the affidavit. So I don't believe that, if there's other evidence Jacksonville knows would give a reason to go outside the warrant if that's not something that's included in the affidavit. I've given my reasons why I don't believe this is severable at all. But I think even if it is found to be severable, this date range, and this is what I was prepared to argue before last week, is overbroad as it is. Again, anything before June 14th, I think could not be relevant. This has a 1.5 month range, far beyond what they found in Demons to be appropriate, which was just a few hours before and after shooting. So in no way am I conceding that this warrant is severable at all, but even if it is, the date range we have is substantially overbroad, and I believe it would be a violation of Blake in the many cases that it addresses.
Okay. Interesting. All right. I'm going to take this one under advisement as well. But State, if I were you, I would start looking at the items of evidence that you would specifically intend to introduce. And if it was outside of the date range that was in the warrant application, which would be June 1 through July 12th of 2024. And the only reason law enforcement gets a hold of it is because the account was backed up. That's the only way they get it. You all need to start looking at what items of evidence you would actually intend to introduce, and you need to have an argument as to why. Okay?
What?
Start doing that.
She might grant
Right?
that one.
All right. Very good.
She might grant that one. All right, guys, let's come on over here. I have been in Sean's, I've been in his case file, and this is a listing of everything that the judge has to rule upon for Sean's case. She hasn't, I just checked it. This is Tuesday's docket. You could see the stamp right here, filed on March 3rd. That one's still outstanding. And as of this morning, she hasn't made a decision on it. And just listening to that right there, she's kind of warning the state like, hey, Detective Ramos was here. In the search warrant, they got a search warrant to search Sean's phone. What they did is they gave the search warrant to Apple. Apple gave them everything, okay? Everything in little boy Sean's phone. But sometimes you have to limit the scope in what you're searching for when you give it to a judge, for when law enforcement brings it to the judge saying, hey, we have probable cause to search this person's iCloud account, but you have to limit the scope in what you're looking for. You can't get everything. They gave him everything. So I wonder if this lawyer is going to get the text between Sean's mom and Sean with the code to the safe thrown out. That would be crazy. I mean, he's still cooked anyway because we have him on camera. Like they're all still cooked. But it's like we talked about, it's fruit of a poisonous tree. We talked about it with the stop, right? The traffic stop. When the traffic stop happened They smelled marijuana. One cop smelled marijuana, and then that gave them, and the tinted windows or whatever, that gave them what they believed to be probable cause for the stop, a pretext stop, right? And then you find the gun. He's under 18. He's not supposed to, he's under 21. He's 18 at the time. He's not supposed to have it. Now, that led to a search warrant of the house, which led to the search warrant of the phone, which led to the search warrant of this. So with law enforcement, if they make mistakes in how they collect evidence and what the probable cause looks like, it breaks the chain, right? So, I mean, he's still cooked. But if that lawyer beats that, wow, I mean, that's pretty good, right? Let's look at this. Here's the motions hearing. So she has not made a decision on motion number 1, okay? That is the warrantless search of the car, right? So his vehicle, that's number 1, and all evidence subsequently obtained as a result of that search, right? She has taken it under advisement. She will issue a written order. As of today, March 6th at 1 p.m., she has not made a decision yet. The one we just heard about is number 2, defendant's motion to suppress evidence illegally obtained from his iCloud account. She took that under advisement and she will write a written order. As of right now, 1 p.m. on Friday, March 16th, she hasn't made a decision on that. Here's what she has made a decision on. His motion to sever count 6 and the state's response to sever count 6 is denied. Sean going to court. The state's first penalty phase for the order in limine. These are some of the death penalty things that I was telling you guys about. The state's penalty phase motion that was granted. Number 5 was granted. Number 6 was granted. 7 is granted. All of that has to do with sentencing and the death penalty. 8 granted. 9 granted. She really sided with the state there. 10, the state's motion to compel the defendant to provide penalty witnesses and evidence granted. Motion to bar the imposition of the death sentence on grounds of Florida's capital sentencing procedure is unconstitutional. She denied that. Motion for victim impact statements to be read by a neutral party. She denied that. Motion to declare the death penalty or victim impact evidence unconstitutional. She denied that. 14, motion to preclude any death penalty proceedings based on violation of constitutional rights. Of course, she denied that. 15, he took out. So motion to strike proposed aggravated factor number 1 in the intent to seek the death penalty. They withdrew that, so she didn't need to make a decision. Then lastly, a motion to declare this Florida statute unconstitutional on its face, and that's the death penalty statute. She denied that. So that is the latest on Sean. But on Tuesday, he brought forward 16 motions. She still has 2 outstanding. You know, she really sided with the state. So Sean's not even a little cooked. Sean's cooked. It's pretty bad. All right. That covers Sean and Rashad. Let's see what else happens in this hearing. We got about an hour to go, but let's keep going. If you guys have not filled out the poll, I do have that in the chat. If you think the death penalty is harsh here, or should the shooter be the only one that gets it, or do all of the boys get it? Let me know what you think in that poll, and we'll look at the results shortly. But let's go back on in.
I think that's it on the motions to suppress, correct?
Yes, Your Honor.
Okay. All right, it's 12:06, so let's go ahead and take our lunch recess, and we will reconvene, let's say 1:40, and we will continue on with the penalty phase motions.
All right. We have TiVo time, so I can skip through all of that stuff. Let's go ahead and skip it. They're back right here.
Okay, good afternoon. We're ready to move on, or move, I guess, back to the penalty phase motions. And I did take a look at the scheduling order that I entered. And the defendants were supposed to have disclosed all penalty phase witnesses, including expert witnesses, by November 17th of 2025. For any expert witnesses, the defense must also disclose any and all records relied upon by the experts in reaching their opinions, as well as any reports issued by the same expert witnesses. And the state had until December 15th of 2025 to disclose all penalty phase rebuttal witnesses, including expert witnesses, with the same requirement to disclose any and all records relied upon by the experts. So I'm assuming everyone's complied with the court order.
Judge, we did list a witness, an expert, and I believe we've drawn his name since we listed him. Does that sound right? Dr. Myers. Yeah, we have been working on trying to replace him. He had to jump off because of volume of other cases. So we're searching right now. We've been searching. So.
Okay. Is he what type of expert is he? Mental health, rebuttal?
Yes, he was a forensic psychiatrist.
Okay. And,
That's for potential rebuttal testimony.
okay. And then have any of the defendants listed a mental health mitigation expert for penalty
Judge,
phase?
if I could just ask a question regarding Mr. Harmon's statement. I assume that was Dr. Myers as it relates to a particular defendant, Mr. Murphy, or?
Oh, no, it was Dr. Myers. I listed him and I believe all defendants.
Okay, okay.
Yes.
Okay. So have the defendants identified mental health mitigation experts in their penalty phase witness list?
Judge, Jenna Finkelstein on behalf of Sean Gathright. I did list a doctor, and I indicated on there it was for mental mitigation. We are working on scheduling her deposition. I provided a couple of dates. I do not have a report yet, so I'm hoping she gets that over to me. I spoke with her yesterday. That way I can get it to the state before the deposition. As far as records, there really isn't much, so I shouldn't have anything voluminous to send over.
Is the depot scheduled?
We talked about 2 dates. I sent over 2 dates yesterday. We don't have it yet scheduled, but we were looking at March, I think I said 25th and 27th.
Okay. What about Mr. Chance?
We listed 2 doctors, they to remove one, but the other doctor we have scheduled for Monday.
For depot?
For deposition.
Okay.
She didn't do a report, and I'll verify that. I don't believe she has any record for themselves.
Okay, that's fine. Well, at a minimum, at her deposition, she needs to be prepared to answer. She relied upon any records and to bring them with her so they can be disclosed. Okay, what about Mr. Davion Murphy?
Yes, so we listed one expert. He has been disclosed. The report has been disclosed. The documents have been disclosed. There might be a potential for listing another expert because we're waiting on an order, and I advised Mr. Harmon of this. We're waiting on an order, perhaps we're going to have it, for funding for a neurologist. And then funds to expend for potential brain scans.
Okay, and what type of doctor is the expert that you have listed?
He is a neuropsychologist.
Okay. This would be a different type of expert?
This is a neurologist. We would need a neurologist and then a neuropsychiatrist.
But you have the person lined up, correct?
Yeah, we're just waiting on the orders.
Let me take a look.
I didn't file these motions, but I was in trial, but,
Let me just take a look. There's nothing in my queue. I think I signed some orders a couple days ago
okay.
that were,
Oh, order on neurologist, okay. Okay, so let's continue.
yep, I signed both those orders on yesterday.
Yes, so the neurologist and then the funding for the reading and scans.
Yeah, I'm not looking at the orders. I'm just looking at the title, but I signed 2 orders yesterday for your client. So I'm assuming that's what they are. So the fund's been authorized. So how quickly can you get this expert witness listed in discovery?
I would first have to get this, and my client, potentially, well, first I need a script, then I have to get my client to the facility to get scanned, then I have to get those discs, then I have to send them to
the other individual, and so it'll take a little bit.
Okay.
Part of the issue will be also working with the facility to get a date
Okay.
and transport.
All right, so Mr. Davion Murphy still needs to identify his second expert that he intends to call. Mr. Chance and Mr. Gathright have identified their potential mental health expert witnesses. And then what's going on with Mr. Rashad Murphy?
Judge, don't quote me, but I believe the court might have had a colloquy with Mr. Hernandez this morning, and Mr. Harmon maybe can correct me. Conversations with Mr. Hernandez about proposing his expert.
Yes.
But he's listed him.
Yes, he said he had listed him. I'm not sure what type of documentation
Sure, that's fine.
followed, but yes, he's been listed.
At this point, I'm just trying to make sure all of the witnesses have been identified.
Judge, although I can't tell the court I was 1,000% listening, that's what I recall happening this morning, is that Mr. Harmon acknowledged that Mr. Hernandez had provided him the name of an expert.
Yeah, so Judge, just to put on the record, all penalty phase counsel has been communicating, we've all been communicating by email about these experts, setting them for deposition, and it's been going on very well. All of them have been in communication with me, trying to provide dates and get dates from their experts. Mr. Hernandez emailed me on the 25th of February about Dr. Collins, I believe. Is that correct? Brian, does that sound right?
Scott, I can't tell you.
Okay, so Dr. Collins, he is planning on visiting Mr. Murphy one more time. I propose to posing him in mid to late March if that works, and that does work for me as long as I can, have time to get him deposed and get the transcripts back. So,
Okay. So let me just take a look at the calendar here. So Mr. Harmon, for all of the experts that have been identified, the defense experts, has a deposition date been scheduled?
not for all of them. I believe the only one I have scheduled right now is with Mr. Petridis. Is that correct, counsel?
We are scheduled for Monday, yes.
For Monday, yes. Ms. Finkelstein's already indicated she provided dates, and hopefully we'll have that set up by hopefully the end of the day. Ms. Toomey has provided dates, is that correct?
That's correct.
Yeah. So I was out yesterday. I know they both sent emails to me, so I haven't had a chance to review them.
Okay. So you guys have until today's Wednesday, close of business this Friday. I want you all to at least have dates agreed to, okay? For any outstanding witnesses, specifically the expert witnesses. And then as to the potential new expert for Davion Murphy, the neurologist, how much time do you need?
Judge, I'm gonna have to get with the doctor and see how quickly he can go out and see him so that I can get the script, and then I
Okay.
can contact the facility. So I can email him now during this
Yeah.
afternoon and see when's the earliest he can.
And it needs to be rapido, not, because we gotta start, I want this done before we start picking our jury, okay? So my preference would be on or before, at least gets identified on or before March the 20th.
Judge, back to the setting of depositions for all witnesses, including experts. I'm responsible for doing the penalty phase lay witnesses, and there are numerous ones, and I have not started to coordinate. Could I have by the end of the week?
Yeah.
Thank you,
At 5 p.m., March the 6th.
thank you.
All depositions need to be on the books, okay? And then state, how much time do you need to get your rebuttal, penalty phase rebuttal expert identified?
I would ask for at least till the end of this week. I've been speaking with Ms. Toomey about her potential anticipated expert. I've already started looking for a rebuttal witness for that anticipated testimony, depending on if that the PET scans or brain scans lead to what I'm believing it may or what they may present, so.
Okay. So are you telling me that you've got to for sure hear from Ms. Toomey regarding this neurologist before you can identify your potential penalty phase rebuttal
Well, she had
expert?
mentioned Dr. Wu, and I've dealt with Dr. Wu before. You may recall Dr. Holt.
So I know this part is a little boring, guys, but they're talking about expert witnesses and things that they need to do by the close of business day today. This shows us that we're getting very, very close to trial. As I mentioned, I am in all of their case files, and Sean Gaithright has put up his witness list. So this is, we're going to trial, chat. We are going to trial. And the expert witnesses are on here. So Sean's is in. We'll see if the other guys, if they've got their stuff together. But it's getting close.
Older from the, I want to say the Ritchie case. He has now become medically incapacitated, so I'm trying to find another radiologist, neurologist to provide.
Okay.
But I started, she had brought that to my attention last week, when we were all having discussions about where we're at in penalty phase with our preparation, and I started looking, so.
Okay. So Ms. Toomey, see if you can make contact with your potential expert this afternoon, and then we'll discuss this again. Okay?
Yes.
Okay. All right, so let's start off with the state's motions in limine. You all were present. So state's first penalty phase motion for order in limine. Is there any objection to that being granted? Okay, for Mr. Chance, Mr. Gathright,
No, Your Honor.
okay, and Mr. Davion Murphy.
No, Your Honor.
Okay, so that motion will be granted as to all defendants. Moving on to state's second penalty phase motion for order in limine, having to do with regards to any argument or evidence concerning the actual method of execution or any description of an execution or the method of execution. Any objection by Mr. Chance for this motion being granted?
No, Your Honor.
Any objection from Mr. Gathright?
No, Your Honor.
Any objection from Mr. Davion Murphy?
No, Your Honor.
Okay, this motion will be granted as to all defendants. All right, next up, state's third penalty phase motion for order in limine regarding the individual beliefs of any person, organization, or religion on the death penalty. Mr. Chance, Mr. Petratus, on behalf of Mr. Chance, any objection to this motion?
No, Your Honor.
Any objection by Mr. Gathright?
Your Honor, I don't have an objection. What I did advise Mr. Harmon, and I believe it's not stated in the motion, so it shouldn't be an issue. He said argument or evidence. Obviously, this comes up in jury selection. I just wanted to make sure it wasn't.
Yeah, no, we're just talking about penalty phase evidence. Okay, all right, and then Davion Murphy, any objection?
No, Your Honor.
Okay, this motion will be granted as to all defendants. State's fourth penalty phase motion for order in limine. This has to do with any description of death, including any deaths depicted in any novel, motion picture, or television show. Mr. Petratus, on behalf of Mr. Chance, any objection to this motion?
No, Your Honor.
Mr. Gathright, any objection?
No.
Excuse me, on behalf of Mr. Gathright.
No, Your Honor.
And on behalf of Mr. Davion Murphy, any objection?
No.
Okay, this motion will be granted as to all defendants. State's fifth penalty phase motion regarding comparing the facts of this case specifically to any other capital case. Any objection to me granting this motion? Mr. Petratus, on behalf of Mr. Chance.
No, Your Honor.
As to Mr. Gathright, any objection?
No, Your Honor.
And Mr. Davion Murphy, any objection?
No, Your Honor.
No,
Okay,
no, Your Honor. I was just making sure I didn't.
sure. This motion will be granted as to all defendants.
Oh, shoot, chat. You know what I just realized? Remember how I told you yesterday I checked Davion's calendar to see when his trial's going to start? I'm not in Isaiah's. I'm in what's it called? The other one, Sean's. Sean has a date change in here too. It says the jury trial starts on April 8th. That's in like 2-3 weeks. Chad, we might be going a little bit sooner than I thought.
State 6 penalty phase motion having to do with the changing the laws regarding the death penalty in the state of Florida. Any objection, Mr. Petratus, on behalf of Mr. Chance to this motion? On behalf of Mr. Gathright, any objection?
No, Your Honor.
On behalf of Mr. Davion Murphy, any objection?
No.
Okay, this motion will be granted as to all defendants. And as to all defendants, the state filed the state's motion to compel that the defendant provide penalty phase witnesses and evidence. And this motion will be granted as to all. And again, I have a scheduling order, and we will continue to discuss this. And as always, if there's an issue, just let me know. The sooner you let me know, the quicker I can deal with it. Okay, I think that's it for the state's motions. So let me just break down. We're going to start with Mr. Chance.
All right, now we're going to Isaiah's motions. We did Sean and Rashad. Now we're doing Isaiah's.
Hold on 1 second. Let me get all of Mr. Chance's motions in front of me.
Yes, Your Honor.
Mama is on the witness list, but keep in mind, you're trying to get that iCloud stuff out. So I'm gonna watch this and see if she makes a decision today.
Okay, very good. I have them. Where would you like to begin, Mr. Petratus?
Whatever the courts, I know you have them in order.
I just will go in the order I have them right now.
Yes, Your Honor.
Okay, very good. Okay, let's start with the motion to declare section 921.141 L, I believe, Florida statutes unconstitutional and to bar state's use of hearsay evidence in penalty phase proceedings. Right? Any?
Judge, I'm going to rely on the motion and the case law contained therein and have no further argument.
Okay. And Mr. Harmon?
Judge, we filed responses to all of Mr. Chance's motions, and we'll rely upon our written response.
Okay. All right, I will deny the motion to declare statute 921.141, I believe that's L, unconstitutional, and I will also deny the request to bar the state's use of hearsay evidence. Hearsay evidence is admissible out of penalty phase proceeding, assuming that the defense is given a chance to rebut that evidence. So that motion will be denied. All right, next up, motion for findings of fact by the jury.
Yes, Your Honor, we would, Mr. Chance, we would rely on the argument and case law contained therein, have no further argument here today.
Okay, state,
Your Honor, we filed a written response. I'll rely upon the state's response.
okay. And just for the record, this motion would, is asking that I say that the jury's got to find additional findings of fact other than what the jury instructions require them to do in a capital case. So I will deny the motion. All right, motion to declare 91.141 unconstitutional.
Judge, but we would rely on the motion, argument, and case law contained therein.
Okay, and this is the criminal gang member aggravator, correct?
Correct, Your Honor.
Okay, Mr. Harmon,
Judge, we filed a written response. We would rely upon that. in the argument that the aggravator is constitutional, especially in light of the heavy amount of evidence of showing a nexus between the facts and the aggravator.
Okay. That motion will be denied.
All right,
All
that's
right.
the gang enhancement.
Motion to declare cold calculated and premeditated aggravator unconstitutional.
The same, Judge. We would rely on the motion and the case law therein.
State you rely upon your response.
Yes, Your Honor.
Okay, I will deny
Denied.
that motion.
She's gonna deny all of them.
Motion to declare 921.141, 2 and 3 Florida statutes unconstitutional. Mitigation must outweigh aggravation.
Same, Your Honor. We would rely on the motion, the argument, and the case law contained therein.
Okay. Mr. Harmon,
Your Honor, we'll rely upon our written response.
okay. We're going to stick with what is required currently under the law for the jury, so I'm going to deny that motion.
Yeah, a lot of these are going to be denied. This is all that sentencing and punishment stuff that we've been talking about. Rashad, when he already went, he went first, and all of those got denied. There was like a very small portion that was approved, but Sean didn't really get into that. He just talked about his two big motions, one being the search of the car, the other being search of the iCloud. And now we're going through Isaiah right now. A lot of these are going to be denied because if she denied it for Isaiah, she's going to deny it for, I'm sorry, if she denied it for Rashad, she's going to deny it for Isaiah.
Motion to declare Florida's death penalty unconstitutional based on violations of Article 1, Section 4 of the Florida Constitution and the First and 14th Amendments to the United States Constitution. Mr. Petratus?
No further argument, Judge. We rely on the motion, the cases and statutes contained therein.
Okay. Mr. Harmon, you rely upon your response?
Yes, Your Honor.
Okay. I will deny that motion. Motion to declare 921.141.7 Florida statute unconstitutional and for pretrial determination of admissibility of all victim impact evidence. As to the, let me see, unconstitutionality of victim impact evidence, any additional argument, Mr. Petratus?
The only thing additional I'd say is I know the court had a specific ruling as to when Mr. Hernandez was up there. I believe you said it to all defendants. So
Yeah.
other than
So, yes, so any victim impact evidence has got to be in written form, and the state has to provide that letter, that written form to you all at least 24 hours before any person would testify. And at this point, it's got to be an adult. And at this point, the state's not limited to the number of individuals. However, at some point they may be, so you can always renew an objection if you feel that there are too many individuals that they intend to call for victim impact.
Yes, Your Honor. No further argument other than that, Your Honor.
Okay, so I will deny the motion as to the unconstitutionality of section 921.141 subsection 7, and I will grant the motion with regards to pretrial determination of admissibility of all victim impact evidence, in that the state's got to disclose what they intend to have read to the jury, and then if there's a dispute or a challenge, I'll hear it.
Yes, Your Honor.
Okay,
Thank you.
so denied in part, granted in part. Okay, defendant's motion to preclude imposition of capital punishment.
Judge, I'll just rely on the motion and the case law I cited in the motion.
At this point, well, any response, Mr. Harmon?
No, Your Honor, other than our written response. Your Honor.
Okay. So at this point, I read this as a wholesale motion to preclude imposition of capital punishment. So I'm going to deny the motion. However, you're not prevented in the future from particularly assuming we get there at a Spencer hearing, any arguments that are available to you legally.
Yes, Your Honor. Thank you.
But um, that motion will be denied. All right. Do you have any others?
I have one more.
Okay.
I believe objection to death qualification of the jury.
All right. I don't see that, but it may be here somewhere. And tell me what the motion is.
I should have it here, Your Honor. That's a
Oh,
long
wait,
one.
hold on.
If I could,
Well, it was when everything was in line, but I took it all out. So now it's good luck. Okay. Good luck putting that. Okay. Oh, here I've got it. Good luck putting that genie back in the box.
Since we're talking about Isaiah Chance, I'm in his case file and his dates have changed too. It looks like this trial is starting on April 8th. And she blocked it out into the 15th. So because it's 4 defendants, kind of like YSL, if you guys watched that with me, these things can be a little complex because it's going to take a while. It's not going to be like Alicia where her trial was up in 7 days. If we start on the 8th and she has it blocked out to the 15th, that means she gave us 1, 2, 3, 4. Let me see, 5, 6. She blocked out 6 weeks for this trial. So it's going to be the big April one. Now it looks like it's going to conflict with Courtney Clenny, but that's okay. Let's go back on in and see what else they're talking about here.
All right. Let me just take a look. Okay. State any further response?
No, Your Honor, we filed a written response. There are multiple grounds raised in the motion other than death qualification. We addressed each in our written response.
All right. The motion will be denied.
thank you, Your Honor. I believe that's the last one I filed.
Okay. All right. So moving on, Mr. Gathright, on behalf of Mr. Gathright. Okay. Do you have a particular preference as to order?
You can tell me.
Okay, all right. I'll just
Whatever you
go-
have there, I'll go with you.
Okay, I'll just go in the order I currently have them.
Okay.
Okay. So, motion for victim impact statements to be read by a neutral party. State what's your response to that.
Is this the motion on the general procedure?
No, this would be Gathright, motion for victim impact statement to be read by a neutral party. I guess they don't want an actual,
I believe I filed a response.
yeah, you did.
And we object, obviously, to that.
Right. I mean, family members can read their statements, correct? Under the law,
Yes.
can and they do.
And Your Honor, we would just ask for the same ruling or indication from the court as you did earlier, as far as if there's any minors.
Right. So same situation, any victim impact evidence, if there's going to be a written statement that's read, it has to be provided to defense at least 24 hours before the victim reads the statement. And at this point, it cannot be a minor unless we talk about it. And if there's any dispute, then I'll take a look at it and I will resolve the issue. So as to the specific request that the victim impact statements be read by a neutral party, I'm going to deny that motion. Motion to declare Florida Statute 921.1418 victim impact evidence unconstitutional.
Yes, Your Honor, we'd rely on our motion.
Okay, state you rely upon your response.
Yes, Your Honor.
Okay, that motion will be denied. Motion to preclude any potential death penalty proceedings based on violations of the constitutional right to a grand jury indictment.
We would rely on our
Motion, Your Honor, indicating aggravating circumstances or elements of a capital homicide which must be pled by the state attorney and unanimously found by a jury.
Okay, Mr. Harmon, you rely upon your response.
Yes, Your Honor.
Okay, that motion will be denied. Motion to strike proposed aggravating factor number 1 from the state's notice.
And Your Honor, I think based on a conversation we had last week, we can withdraw that motion. My understanding is the state's solely relying on the facts of this case that will be
Right.
heard in guilt phase.
A contemporaneous conviction, not anything prior.
Right.
All right, so that motion is withdrawn. Next up, motion to declare section 91.1416C unconstitutional on its face and as applied. This is the risk of harm
Yes.
aggravator.
Great risk of harm aggravator, finding it vague and overly broad. We rely on the memo in our motion.
Okay. Mr. Harmon, you rely upon your response.
Yes, Your Honor.
Okay, that motion will be denied. And motion to bar imposition of death sentence on grounds that Florida's capital sentencing procedure is unconstitutional.
Yes, Your Honor, we have indicated in that motion that the procedure is currently unconstitutional, permitting a verdict of death on a non-unanimous vote of the jury, and would rely on the memo contained in our motion.
State, you rely upon your response.
Yes, Your Honor.
All right, that motion will be denied. Do you have any others?
We had, it looks like, motion to declare 921-1416I unconstitutional.
Somebody doorbell.
Let's see, and that's for CCP.
Okay,
You see
and
that?
I've
one?
been saying I, is it I or one? I don't know.
It's aye.
Okay.
We'd rely on our motion.
Okay.
If you have it. You have it.
No, but if I mean, the motion is filed as to declare the CCP aggravator unconstitutional.
Correct.
Okay, that motion will be denied.
Let me just double check. And we did have a few motions in limine. I think we can agree on most of them, but
Did
just,
you cover the victim impact?
we did.
Yeah.
Both were denied.
There's a motion to only as to general procedures, I believe.
Yes. Oh, and I'm sorry, Your Honor, there is one more we filed the motion to strike the aggravator that was withdrawn, but we do have a motion to declare 921-1416B, the prior capital or violent felony, the constitutionality of that. And we'd rely on that motion if you have it. That one was filed. Some of these were filed at different times, which would be, that one was filed early January. The state did file a response to that as well.
Okay, do you rely upon your response?
Yes, Your Honor.
Okay, that motion will be denied.
I think that was it for the constitutional and those motions. We do have a motion in limine for general procedures.
Okay, what does it state?
The first one, I believe the state didn't have any objection. Section A of that motion was reference to non-statutory mitigating circumstances and use of words such as catch-all.
Yeah, we have no objections.
Okay, granted.
The next one was section B, the presence of media, family members, and uniformed officers and shackling of the defendant.
Are they going to be
Okay.
I
shackled?
know this, go ahead.
No, it's okay. Your Honor, I spoke to counsel about this last week. We agreed, obviously, to any kind of shackling in the presence of the jury during the guilt phase. It's my recollection from Cusco, and I believe Richie possibly, that during penalty phase, we maintained that.
Yeah, they did it to Daryl Brooks. Daryl Brooks was in his full jumpsuit.
Yes.
Okay. As far as the other matters in that ground, we would defer to the court as far as the media, anything like that.
Okay. And tell me, I feel like I've seen the motion, but I can't find it right now on my desk. So,
Your Honor, essentially, we are asking that the court instruct the members of the media to not interview witnesses, family members, courtroom personnel, people involved in a place in the courthouse that could be subject to the jurors observing, seeing.
Okay.
I believe there's
That is because of Alicia's damn case. I want to talk to the mama. I do. I mean, come on. Please deny that. Like, it's messing with freedom of speech.
also the ground about use of cameras in the courtroom. If I'm just kind of looking at this from last week, there's an administrative order that deals with that. as far
Right,
as-
there's only one camera that's permitted in the courtroom and it's got to be out of the way. And I do have a whole discussion with the jurors that they understand that their faces will not be shown, their identities will not be disclosed. So, I guess the motion will be granted in that they've got to, the media knows, and they've got to follow a certain procedure established by the courts. And I assume they will.
Perfect.
I guess I
The
can't talk
next
to mama.
section, we were asking C, names and addresses of potential jurors summoned to try the case and do individual questionnaires. I don't believe that's your honor's practice, but we were seeking to do individual questionnaires for the jurors.
Okay, that will be denied. And then as far as the names and addresses, we get those the day the jury gets pulled. So, and I think I told you all we're gonna do 3 days of 150 back to back. So you'll get the 150 on the Wednesday, the next 150 on Thursday, the next 150 on Friday, the morning of.
Okay.
Okay. So you'll get them, but not before that.
Not now.
Okay, so what they're talking about, 3 days of 150, that means that jury selection, we're getting very close to trial if they're talking about jury selection. That means that they're going to filter through people. Everybody's going to, get their notices in the mail that they have jury duty, right? They're going to interview 150 people over on one day. The second day, they're going to do another batch of 150 people. And then on the third day, they're going to do another batch of 150 people. Okay, so it looks like they're going to take 3 days to select and impanel their juries. Wow, it's getting real, chat. It's getting very real. We're getting very close.
So I guess it's granted, but you'll get it the day of.
And we were also asking for individual and sequestered voir dire. My understanding is that the court does the individual or smaller groups as to hardship or media exposure.
Yeah, so individual voir dire will be done on anybody that thinks they know anything about this case. With regards to hardship, that will be done as a group for those that are claiming a hardship. And then on death penalty voir dire, that will be done again in small groups. That's not my traditional practice, but because of just the number of people that will be coming through for jury selection, I am going to break it down, the death penalty qualification questions into smaller groups. So probably the 30 to 40 range, we'll see whatever we think we can get through in a day. So, and I think I did mention this before that normally I have a whole speech that I do before phase 2, which is death qualification. And I know the state has Mr. Harmon has a speech that I've seen him do before he begins. And normally I give the speech when we actually move on to phase 2. But in this case, what I'm going to do is I'm going to give my speech first thing Wednesday, Thursday, and Friday to the group of 150 as a whole, just because it is can be time consuming. And by the time I get done talking, and by the time Mr. Harmon gets done talking, and then if the defendants wish to make a statement regarding penalty phase questions, it's, we're now into an hour and a half and we haven't even started talking to any of the jurors. So my plan is that Wednesday, Thursday, and Friday, the first week of picking the jury, I will give my speech to everyone there, but I will remind them that we're not going to be asking them any questions related to the death penalty in phase 1. And then if those that come back to go into phase 2, which are the death penalty questions, I will then just give them a brief reminder of what I said to them. And then I'll give Mr. Harmon a chance and the defense counsel a chance to give a brief reminder before we actually begin the questioning of the jurors.
Okay.
So if you all want to make a succinct speech regarding death penalty voir dire,
Okay.
you're welcome to do so. Okay? But you'll do it Wednesday, Thursday, Friday morning
Once
of
we
the
pare
group.
down a little bit.
Well, you do it initially to the whole group.
Okay,
And then those that make it to phase 2, like I said, we'll do just a quick reminder of the points that were made when they first came in. But we're not going to do another wholesale intro for each of those small groups because it'll take forever. Okay?
Okay.
Okay.
Let's see, next was section E, objections being made contemporaneously with the occurrence of error to avoid procedural default. No, did we discuss that, Scott? I don't remember if you had an agreement to that or not.
Yeah, how are they going to do objections?
Okay.
So is there any objection?
Judge, I would just, so when I just tried to ask counsel.
How do we, I forget how we did objections with the YSL case because it was 6 defendants. I think objections were flying everywhere. It was mostly Miss Love, if you remember that. But when you have a group of defendants, that's what they're talking through right now. It's like the court logistics.
Clarification about contemporaneous objections. Objections made at the bench, objections made from counsel's table.
Just so there's not speaking objections from the
Right.
council table.
Granted,
Thank you.
I don't like speaking objections.
No, I don't think anybody does.
Some people like them. Or at least some people like
That's
to
true.
make them. They
Yes.
do, but,
Or some judges, when you say, can we approach, and they say no, and then you have to do it. So.
right.
And the last one, I believe, is section F, which was miscellaneous matters. And I believe that the state is in agreement with that section.
Yeah,
Correct
Your
me if
Honor,
I'm
I
wrong.
know it's the court's, in the past, being in front of Your Honor, when the state asks for the record to reflect that a witness has identified the defendant, the record will still reflect.
Right. That's all I ever say.
Perfect.
So I guess it's granted with the understanding that that's what I will say.
Okay. And I believe that is it. We handled the state's motions and limine. Is that all you have?
Yes.
Okay.
Okay,
That's all
all
on
right.
behalf of Mr. Gathright. Thank you. Your Honor.
Okay, thank you.
All right, so Sean's all
Okay,
set.
and Mr. Davion Murphy.
Davion's the last one. We're going to go through his motions, and that should conclude this hearing.
All right, you want to start off with defendant's motion to strike aggravating factor, section 921.1416N as unconstitutional. And that's the criminal gang member aggravator, correct?
Judge, are you talking about my motion to strike? I apologize.
Yes.
Okay, so my motion to strike the aggravating factor 921.141BN.
Oh, we're switching to a different, I was
Oh.
looking at 6N,
Okay.
but that's fine. We can start wherever you want to
No,
start.
I was going to start at the general procedures
Oh.
and work from there, but whatever Your Honor wants.
Okay, it really doesn't matter.
I think it's probably easier. Not that anyone needs to be hard.
That's fine. So where do you want to start?
The motion in limine regarding general procedures, I
Okay.
spoke with the state. I think we're pretty much in agreement.
Yeah, the motion is very similar to Mr. Gaffrey's motion.
In that it appears the state agrees with paragraph A,
I do, the state does agree with that.
and that
Okay.
is in regarding the non-statutory mitigating circumstances. Paragraph B, if I recall, you left that up to the court's discretion, and that will be the presence of media, family members, and uniformed officers and shackling of the defendant.
I don't think we address family members, as far as that goes, I don't think there's any limits to family members being in the courtroom. We always instruct them not to wear anything that's provocative to the jury, such as photographs or any kind of remembrances.
Right.
Yeah, Davion definitely looks like Corey Holcomb. Like he really does. Shout out to the International Quiet Storm. He definitely looks like Corey Holcomb. We have a Corey Holcomb lookalike That is interesting. The other day in last week's hearing, we were looking at his tattoos. So we know that he was trying to get that suppressed. I don't know if she's ruled upon that yet, but it is interesting. As far as Alicia's baby daddy, Isaiah Chance, yes, he is one of the 4 defendants. He's sitting over to the right. The camera doesn't really go on him that much. I've been in other chats where people are like, Sean Gaithwright's cute. Don't convict him. I'm like, y'all are doing this whole Luigi thing again. That boy had a whole, like a giant gun practically shooting at Fulio's car. I think he was the main shooter, to be honest. So it's crazy work to hear some of these people like, no, don't lock the cute one away. Like, ma'am, please sit down. But let's get back to this. We got a few more minutes to go, chat. And then I know I have some super chats to read. I will read them. This case is starting in less than a few weeks. I thought we were going to go in May, but now it looks like it has been moved up to the first week of April. Let's get it, chat. These are the last few things that they need to talk about during trial. And real quick, just because I got my sis in the building, shout out to Messy Michonne, y'all. She is a wonderful content creator. She has been dominating my feed. Every time I go to YouTube, Michonne is live or she's doing something and she's covering all types of things. So y'all check out Messy Michonne. I always love shouting out content creators when they are in the chat. She is so funny. She has me dying. Now she has this new microphone. It is amazing. Y'all check her out when you can. But let's go back on in. Like I said, we also have another update on Alicia Andrews. She is fighting for a new trial. Judge Sisco has been removed from the case. So she is not presiding over Alicia. It stopped right around the sentencing time. And she is with Judge Hernandez right now. Last I heard, she was looking for a transcript of that October trial so they can get a new trial. And Jeremy, I showed it to you guys on Tuesday, did file that petition for a new trial. I suspect it's going to happen after the boys. Here's why. Because the last thing that is in Alicia's docket is a motion compelling the state to give back evidence that was used in the trial, meaning the state needs the guns and the shell casings from the clerk, right? So the fact that it's being given back to the state, it's either they're going to use that stuff for this trial or it could be for Alicia's trial. At that point on Tuesday, I did not know that she had moved this trial up to the first week of April. So that's probably why the state has that stuff, but it is interesting. But Alicia is fighting. It could go after because there's not enough time to do a trial right now in the month of March. But yes, that is what's happening here. But let's go back on in. We got a few more minutes left and I will read the rest of the super chats, guys. I just like to wait until after we have like breaks and things like that. But got about 20 minutes left. Let's go back in.
And the defendants are shackled, but not obviously to the jury.
Yes, Your Honor.
And so I guess the motion is that paragraph B technically is granted with the understanding that there's an administrative order that deals with the media. Family members can be present. They just can't wear anything that might be considered inflammatory or sending a message to the jury. And uniform officers are obviously can be present in the courtroom they have to have security, and the defendant shall be restrained, but not so that the jury can see.
Yes, Your Honor.
So it's granted to that extent.
And then as it relates to paragraph C, names and addresses of potential jurors summoned to try the case, I heard the court in addressing this motion previously. I guess we obtain or are provided the names and the addresses, I think, the morning of.
Yep. Okay. So no questionnaire, and then you'll get the names the morning of. So deny the motion as to a questionnaire. Granted as to the names and addresses, and again, that will be provided the morning of jury selection.
And then D, individualized and sequestered voir dire. I also heard, Your Honor, as well. I have done it both ways. I feel as if it's more effective, at least to do the penalty phase portion of it individually, as opposed to like in sections of 10 or 15 or what have you, but
yeah, I'm not doing individual. No, we're not doing that. So we're doing, as I said, small groups, anywhere 30 to 45. We're going to see what's workable with the number of attorneys we have, but
Understood.
it's not going to be done individually. So as to paragraph D, that's denied.
And then E would be very similar to what the court has previously ordered with regards to objections. Obviously, there should be no speaking objections.
Right. That's granted.
All right, here you go, acting up again.
And then F has to do with miscellaneous procedures, one of those being where the state wishes to identify a defendant for the quote record. I would ask that that be done at the bench as opposed to the court commenting that the reflection, that the record has reflected that so-and-so, whatever witness has identified the defendant. If that's what the state is requesting, that that be done at the bench.
I'm going to deny that request. So the state can ask it just if the record reflects, and I will indicate if the record so reflects. Okay.
There's no longer the issue with the
Okay.
expert. Okay, so then the next one, if Your Honor may, motion to declare section 921.141B1, which is CCP, which I believe the state filed a response to. And I would just stand on my motion.
That was all CCP.
Yes.
You know what?
6I.
It's 6.
What I-
6I,
maybe I
yep.
said.
Okay. That motion will be denied.
And then the next one would be
Come on, Law and Crime, fix the mic.
921.141.6B.
Unconstitutional as written at, and as applied, and that relates to the prior violent felony aggravator. I believe the state also filed a response.
Does this defendant have an actual prior?
I looked, I thought that it was in the.
Corey, you got a prior?
Does he, or are
In
you
the
just alleging
notice.
the contemporaneous conviction?
Judge, I can't speak to whether he does or not. I know all the defendants were relying upon contemporaneous convictions for violent felonies. I believe this is Mr. Murphy, Davion Murphy.
Yes. I think it said or.
You believe he does, counsel?
I believe that the notice said or.
Or, okay.
Yes.
I believe that's the wording in the statute, so we utilize that wording.
Okay. Well, as to it being unconstitutional, I'll deny the motion. But obviously, before we get into a penalty phase, if the state is going to rely upon a prior violent felony conviction, you got to make sure you've given them the defense. So you need to
Hey, what is
let
that?
them know before the start of defense. Violent felony conviction.
What is on there?
Make sure you've.
What does he have on there? I love her so much. Hold Corey. Corey over here putting up. You cannot make this stuff up. Okay. We have somebody's names. He says somebody is his baby. I can't make out the rest. And it says, I love her so much. I can't make out the rest.
If the state is going to rely upon a prior
My wife, and I love her so much.
violent felony conviction, you got to make sure you've given them.
She's my baby. You cannot make this stuff up with these cases. What is that? I'm not bugging, chat, right? Like, look at this. There's always something that happens in a court case. Marisha Williams something, my wife, she's my baby, and I love her so much. What the You know what? I just be thinking we're just gonna get our coffee, watch court hearings. Nothing's gonna happen. Corey Holcomb over here putting up love letters. What the hell? Yeah, I'm calling it right now. This is gonna be a ratchet trial. I'm calling it right now. Like he's really willing to risk that. And one of y'all saw it in chat earlier. It was one of you guys. You were like, what does the back of that say? Now that I've paused it, just because I was curious, I thought maybe it just had somebody was like, oh, there's an address on there. That ain't no address. That is a message. That is a message from beyond the wall. All right. From jail. All right. Corey Holcomb's stunt double, Davion, has a message. He loves her so much, Miss Williams. I can't read what the first name is, but Miss Williams, Davion from jail and from this court, he's going to get everybody in trouble. He's going to get everybody in trouble. They are literally right now talking about what the housekeeping is going to look like for this trial. Like literally, that's what they're talking about. Davion's bugging. Like you are not on trial for murder, sir. This is not a game.
The defense. So you need to let them know before the start of trial, okay?
And then the next one will be motion to declare 921-1418 unconstitutional and for a pretrial determination on the admissibility of all victim impact evidence.
Okay. So as to it being unconstitutional, I'll deny the motion, but I will grant it with regards to a pretrial determination of admissibility.
Yes. And Zong, obviously, that we received those letters
Yes.
in advance. That
Yeah.
should-
Same ruling, at least 24 hours before anyone should offer the victim impact evidence in court before the jury. Has to be disclosed.
And then I would also adopt, I did not file, although I did tell Mr. Harmon that I was going to be adopting the motions that have been filed on behalf of the other defendants regarding the constitutionality of the new death penalty scheme applying to Mr. Murphy, not based on ex facto or anything of that nature, but based upon just general 8th and 14th Amendment rights. So I would adopt all of those motions and incorporate those
Okay.
in his argument.
Same ruling, be denied.
Okay.
And that's his lawyer talking. That's Davion's
Finally, we
attorney.
have motion to strike the aggravating factor. I think is that what you started with?
I have, defendant's motion to strike aggravating factor, Florida statute section 921.1416N, which is the criminal gang member aggravator. Relying upon your motion?
I'm relying upon my motion. Yes, Judge. Yes, I am.
Okay. State, you're relying upon your response?
Yes, Your Honor.
Okay, the motion will be denied as to the unconstitutionality of that aggravator. All right, Ms. Toomey, any other penalty phase motions?
The only other thing that I might add for the record with regard to this specific aggravating factor, specifically for criminal gang members or associates, that has already been enhanced, I guess, if you will, in the indictment. So it's almost like a doubling up of that sort of kind of enhancement. So I would just make a general constitutional argument against the doubling up.
Okay, same ruling, be denied.
I think that's it.
I believe so.
Yes.
The list I have. Your Honor, if I could readdress my motion to compel, so I can kind of let the court know where we're at as far as documents and records. Ms. Toomey has provided me with voluminous records, and I appreciate that. All types
Of what kind of records?
School records, I believe DCF records, other records, medical records possibly, in relation. Social Security records dealing with Mr. Davion Murphy.
Yes.
I know Mr. Petridis, have you listed more than one expert? Is it multiple?
Yes.
I thought you had, okay. So I haven't received any records from any other penalty counsel. And it's my understanding if there is any that will be provided, I just wanted to bring it to the court's attention.
Okay,
I've reached out to my experts. I don't have anything to say, but I told them to check if they were going to have anything. Obviously, I'll send it to Mr. Harmon immediately.
okay,
That jog my memory, Your Honor, we have a small number of school records from Mr. Gafford. I did a notice of intent to rely, but now that I think about it, I don't think I actually sent the records to the state, so I'll do that today.
okay,
It's a very 10-page email.
okay,
And then I think that's it that we have for records.
okay. And have you received any records from Mr. Hernandez for Rashad Murphy?
I have not, Your Honor.
Judge, I'm going to text Mr. Hernandez now, and I'm going to also make a note to speak with him after the proceedings.
Okay,
And judges, is there a deadline on those records?
well, yes, the deadline is come and gone.
Rapido, I heard the court say rapido.
Pursuant to my scheduling order, this dates have come and gone. But anywho, I tell you what, let's do this. We're reconvening Friday, correct?
We are, Judge.
So I want you all to just make sure you've checked to make sure you have disclosed or are disclosing any records that you're going to rely upon in penalty phase. And then let me know Friday what your status is. And then if they've not been produced, then I'll give you an absolute, like, I'm not kidding deadline. I know my scheduling order should have been an absolute, I'm not kidding deadline, but things happen. So, okay. And Miss Toomey, I know you were busy, but have you heard back from your neurologist by any chance?
I emailed him.
Okay.
And I can.
That's fine. So we're reconvening Friday, so I just need to know by Friday when he's going to be able to get his evaluation done, so that you can determine whether or not you're going to list him.
And that's exactly what I sent, but I had not read.
Okay, that's fine. It's fine. Okay. Okay. Anything else we can get done today? Any suggestions?
Judge, I did have a motion in limine to all defense attorneys to requesting that they provide us with any sort of drill rap videos that they intended to use to list them and provide them in discovery. I don't think we addressed that.
Judge, if the court will allow, I have a brief response on that.
Sure.
Somewhere.
All right, so now we're talking about what songs, videos are going to use at trial. So things like When I See You, the whole Young and Ace thing. They used it at Alicia's trial. All that's fair game.
Judge, if I may, while we're waiting.
Sure.
I did file a motion, I'm assuming that this is probably gonna be heard on Friday with all the other gang stuff.
Yeah, unless it's something we get done today, relatively simply. No? Okay.
Not because of me.
No, I'm not. It's okay.
Judge, if they would prefer it be heard with the other gang motions, that's fine. I just thought that that was something, because I was just asking that it be provided in discovery and listed.
Right, that's what she's asking at this point, not the admissibility, but just that if you've got any other drill rap videos other than what the state is intending, and if you disclose to the defense the ones you actually intend to admit at trial.
Judge, we will. I know we've listed probably more than we intend to use, but we will specifically list the ones that we intend to use.
Okay, yeah, by the time we reconvene Friday, you need to specifically identify the drill rap videos that you want to show the jury. And then if there are any drill rap videos that the defendants wish to show to the jury, they need to be identified and given to the state by Friday.
And Judge, certainly the evidence view, we on Friday are going to talk about getting together. It'll be, as the court can imagine, monstrous.
Yes.
There may be some non-testimonial issues that come out of that evidence view that may be need to be addressed by the court.
Sure.
But we can advise you of that. My only additional concern in this state's motion in limine is that it doesn't limit itself just to videos. It suggests that the defendants refrain from making any direct or indirect mention or introducing into evidence any non-disclosed evidence of the victim's prior gang activity or videos. And I would object, and I don't think it's appropriate to suggest at this stage of the game that we should not be allowed to either question or seek admission of evidence or mention or have argument to what is described as the victim's prior gang activity. Now, granted, the court hasn't ruled on any of these things
Right.
yet, and I don't want to predispose or predetermine what that may or
Corey's doing it again. Look at him. He's doing it again.
may not be. I agree wholeheartedly that we should be providing the state any rap videos we intend. But as it relates to argument or mention or questioning, I don't think that we can blanketly, as the motion is written, at least Rashad Murphy, agree to that.
Okay, and I'm not ruling on that motion yet. That the sole issue that I hear Ms. Doherty raising is she just wants to know if there are any other in the universe of drill rap videos. Are there any other drill rap videos that any of the defendants are going to attempt to introduce at trial?
Understood, Judge.
Guilt phase. So you just need to tell her by Friday if there are. So once I've ruled on the other gang evidence and whether what's coming in or isn't coming in, then once I determine that, then we can start working on the motions in limine. So we'll kick off with the motion for me to determine how much of the gang evidence is going to come in, and then we'll go from there as to the remaining motions. Okay.
Judge, there is one mention I would make. I've been working on, when I can, and because of the late nature of the deposition of state witness Robert Howard,
Sure.
I've been working on what will be a non-testimonial motion in limine as to certain portions of what I anticipate Mr. Howard's testimony will be. And I just wanted to make everybody aware. I had spoken to the state some time ago. We just did get back last week the expedited transcript of Mr. Howard's deposition, although there was a previous proffer that we've been able to rely a little bit on.
I remember Robert Howard. He was in jail, and then he was trying to say that Jeremy said something and was trying to coerce him to testify or something. This was like probably the second to last day of Alicia's trial. So it looks like Robert Howard is being called by Rashad to testify in this one. So that's interesting.
So I anticipate filing that motion as well, Judge, without significant argument other than those portions that we would seek in limine.
Okay.
And, and Judge, I just wanted to comment on my motion limiting because I did include gang activity. Obviously, I know that the court has not made any.
See, Law and Crime keeps focusing on this because we know what Team Ukori is doing. All right. This love letter keeps being shown. We know what he's doing. Because if you're just straightening your papers, there's a way to do that, right? But this is very interesting. A great way to get a message out to somebody.
Rulings about what will be coming in, but the state's concern obviously is bad character on part of the victim being inappropriately admissible by defense and last minute without us having the opportunity to fully vet and make any sort of arguments. So it does include not just the drill rap videos, but any gang activity that they're aware of that they intend to get into that's not been previously disclosed.
Okay. Okay.
This judge.
We'll start with the drill rap videos, and I don't know what that other evidence might be. I'm not really sure. So anyway, we'll see where we are on Friday. Okay. Anything else for today?
Mr. Gafford had a couple of other motions that would fit in any category.
Sure. Just tell me what they are.
One of them maybe we should have done last week, but he has a motion to sever count 6.
Yes.
I think we laid out our position in our memo, and I know the state filed a response.
I
Our
did.
position is it's a separated transaction. I know that the state's position is it's a causal link. But we believe it's sufficiently separated that the jury should be considering count 6 separately from the other counts.
Okay, and remind me, what is count 6?
Judge, that's the tampering with physical evidence that is when Mr. Gathright goes back to his grandmother's house after the offense on the same day and wipes down the car and removes the car from Tampa and leaves it in Auburndale.
Okay. Oh, sorry.
And Judge, we did file a written response to that, again, saying that that is properly joined and requesting that it not be severed, as it specifically is connected and joined in an episodic manner, which I think is the case law, which says that that is properly joined.
Okay. Any response, Mr. Wise?
Only, Your Honor, it's a separate incident that's allegedly taking place. It's happening in Fulton County. It doesn't involve anyone else in the room.
Not Fulton County.
Not the state's position, but it's separate time, separate space. It's two separate acts. It should be tried separately.
Okay. I'm going to deny the motion to sever count 6. Okay. Anything else?
We have filed a motion to compel the location of all license plate readers along this path. That's
Right.
We have hits from, we know where license plate readers hit. I don't know, and I know the state mission discovery, and maybe we missed it. I don't think we have locations of any license plate readers that didn't hit. I know I addressed this in other, at least one other case, and I think there are some law enforcement concerns about disposing it, but I think it's relevant if we're seeing evidence of where it hit. There could be license plate readers along these alleged paths that didn't hit. I think that's.
So you want the state to give you the universe of license plate readers along a
Yes.
travel?
Between here, Orlando, Jacksonville, yeah, along these routes of travel, which I know there's more travel in this case than a lot of cases where, we're talking about just someone traveling to Tampa. But I think it is relevant Brady.
Huh, I don't know that it's Brady. Okay, state, what's your response?
Judge, we have complied and given them all of the license plate readers where they hit. Judge, we don't know the specific path of travel, and I did specifically talk to the detective. If it is not captured on a license plate reader, it's not something that we can use in the particular case. It's a matter of timing and how the car passes. Some of these license plate readers are mobile. And so, Judge, there's no way for us to know. And there are different companies for different license plate readers. There just isn't any it's not exculpatory by any means. And without knowing the specific type of travel, when they got on, when they got off, if they took a break, there's just no way for us to be able to provide that.
But you have provided for the license plate readers that are going to come into evidence, the location of those has been disclosed.
Yes, they are disclosed by address, Judge.
Okay. All right. So I'm going to deny the motion as to any license plate readers that were not triggered during the course of travel of the defendants. Okay. I don't find that it's Brady. Okay. Anything else?
Yes, Judge, there were just, I think there was a couple additional matters. You asked us with regards to that Richardson case that occurred in Jacksonville.
Right.
What was the reason that there were 2 juries, and that was a Bruton issue.
Okay.
And I believe Ms. Ismore has a copy of the actual order that lays that out, if you want us to forward a copy to you as well as defense
That's
counsel.
fine. I take you at your word that it was a Bruton problem. I just was curious.
And then I did want to know if the court wanted to do a formal colloquy on the record. I know that Mr. Petratus had to step out for a moment. I think it was the last time we met for motions for a small period of time. We did go ahead and order the transcripts for what happened during that time period. If Mr. Petratus wanted to take a look at that or had any sort of additional argument to make. I know that there was additional counsel that was tasked with asking questions during that time period on his behalf.
Yeah, and I just want to thank you for reminding me about that. So I think the last 2 witnesses, and I think it was Dravac and was it Trey McCullough?
Yes,
the last
those
2?
were the last 2 witnesses.
And I'm sure you were advised of this, Mr. Petratus, but Detective McCullough had no information related to your client at all. And then Detective Drayback, this was done as a proffer to establish these detectives as gang experts?
Yes, Your Honor.
Okay, and I don't see Detective Drayback being declared an expert in this case, just because the gangs that he is tasked with, and I don't have my notes right in front of me, but there's a different gang or set of gangs in Jacksonville that he's focused on.
Yes, Judge, I believe we just listed him because he's not involved in a specific gang, but was the liaison and handled most of the matters as a general gang expert for Jacksonville gang activity.
Yeah, but you've got 3 other people to choose from,
Yes, Your Honor.
right?
Yes.
So at this point, it'd be cumulative anyway. So yeah, here are my notes actually. His gang of interest is the 21st Street gang. And he testified he doesn't have any specific familiarity with 6 Block, and he's assisted other members of the gang unit with regards to ATK and 1200, but the 21st Street gang is his specific one that he focuses in on. So Detective Drayback is not going to be testifying as a gang expert against Mr. Chance or against any of the defendants in this particular case for that reason. The state's got 3 other people to choose from, and Detective Drayback's gang is not a gang at issue in this trial. Okay, so I did indicate that the state's ordered a copy of the transcript, and if for some reason you wish to ask any further questions of either Detective Drayback or Detective Trey McCullough, then we'll set up a Zoom hearing. So,
Judge, Ms. Ismer was kind enough to provide me with a copy. I read them over. I have no further questions. Mr. Wise asked the questions on my behalf, and I thank him.
Yeah.
I was present for the depositions of those witnesses in Jacksonville, so I anticipated
Right.
that would be the outcome.
yes.
So I appreciate the court.
Yeah. So just wanted to make sure. I don't, just making sure. Okay, and anything else?
No, Your Honor, I think that's all from behalf of the state.
Okay, anything else quickly we can do today? No? Okay, all right. I will see you all Friday morning at 9 a.m. and we will get through all of the remainder of the motions. Oh, also, I did take the motion to sever under advisement. Once I've ruled on the parameters of the other gang evidence that's going to come in, then I'm going to ask each of you to, with specificity, tell me what evidence is admissible in this trial that would not be admissible if your client was being tried alone. Okay? So just be prepared to answer that question.
Okay.
Okay, see you guys Friday morning.
All right, chat.
Do you need my notes?
That concludes the hearing that we saw. This was Tuesday's hearing. She keeps referring to Friday. Today is Friday. They're in court right now. Law and Crime is not live streaming it. However, they usually will put it out the next day. So I'll get the footage like tomorrow or on Sunday so we can look at what happened. But what she just said at the end there was actually super important. So there has been a motion to sever. I assumed that she was just going to try them all together because looking at their docket sheets, everybody has their trial starting on April 8th as of right now. But it looks like she is going to do a few things today. She's asked them to bring their expert witness lists in, their complete witness lists in. I see Sean's is up, but the other 3, I don't see their witness lists in yet. Any drill rap that they're going to be using as evidence, any gang evidence, they're going through that today. But she did ask them specifically, she just talked about this. If you have any evidence that would come in if your client was charged individually that wouldn't apply to this group thing, you need to talk to me about that before I make my decision. So this is pretty huge. We can get some severance happening. We can seriously see some things happening in the next few days. Unfortunately, today's hearing is not it's not televised. I checked local Jacksonville, I checked Court TV, and I also checked Law and Crime. So we're just gonna have to wait until the footage is posted online, and I will show it to you guys then. But it is a big day, and I anticipate that they're probably gonna go until about 3 or 4 o'clock. It's 2 o'clock now, and they've been there since 9. So there's a lot to do, and there's a lot for the judge to go over. Worst case scenario, soon as it's available, I'll go live on Sunday or Monday and we'll watch it. But yeah, so here are a couple business things I need to tell you guys about. Alicia has a hearing next week on the 10th, right? And that's where it's a status hearing. It is over Zoom. So we are going to see if that judge, I think her name is Judge Fernandez, if she is going to grant Alicia an opportunity for a new trial. So we're going to see what happens with that one. Last I heard, Jeremy got the transcript from the October trial, and he found some instances of when there was some bias and why Alicia deserves a new trial. So that judge has also not ruled on that one yet. That's on the 10th. Nathan Wade is on the 13th. So, he wanted to testify on the 13th. He was originally supposed to testify last Friday, the 13th, February 13th, and he did not show up. However, the Senate wants to bring him in before Friday of next week. So little bit of interesting stuff for all my girls in the chat, my women. I need you to do me a favor because it's about to get really busy with all these trials. April, we're going to have Courtney Clenny and this trial. And I think there's some other stuff happening. A bunch of you guys have been asking me to start researching the Dirk trial and do like shorter videos on that. So I will. But I am going to be doing any content creator training this month. So people that want it, March is your month. But I'm also doing a meetup for women only in like Rome or Italy or whatever. Okay. Here's the link. I only want women to fill it out. Okay. It's a survey to see if I do this, where would you guys want to go? Please don't pick Colombia. Nothing, no shade with Colombia. It's on there. It's on there. But in order for me to have a trip, I need to have women that want to attend kind of fill it out and talk about like if they would be interested, where they would want to go, how much they would spend, stuff like that. My vote is Rome. So if you want to take my vote, that's where I want to do it. Right now, here's the thing. Brothers, don't feel left out because here's the link. It's in the chat right now. Brothers, don't feel left out. We're doing this as a trial run because I want to do a bigger one with more people in like January, but I need to test it out with women first. Okay. So ladies, this is your special thing for you. And as we get ready for trials, the other thing that everybody can participate is you guys help me develop merch for every single trial that we cover. So as we're getting closer to this one, please know that we'll be doing like surveys and different fun things for all of our live streams. All right. We have fun over here. We make trial watching interesting. We do. So ladies, please fill that out. Gentlemen, I know you feel left out, but listen, when it's your turn, you can pick whatever you want. I just need to run this company to even make sure that it's the right company that I want to use. Okay. So that's the first business thing. For anybody else, the AV Creator Store is open. That's already in the description box. But we'll go from there. Let me check out our super chats. I did skip a few because I wanted to watch the complete hearing. But this hearing that's happening today is huge. It's going to give us the future of what this case looks like. Are these boys going to be tried together? Are they going to be severed and tried separately? But either way, she has put this case on the calendar for April 8th. Shout out to Mike G, been with me for 8 months. Thank you, Mike. I think you started coming around right around the Fulio trial back in October. Like Alicia's trial. So thank you for coming back and being with me for 8 months. Appreciate your time. Y'all already know him. The Little Gaming Channel, our stream sponsor, gifted, he actually did $200 super chat. So thank you so much, TLGC. Y'all check him out if you have not already. Content creator in his own right. Shout out to Sheriff Chuck, who became a member. Welcome, Sheriff Chuck. You're gonna love it over here. We do a lot of fun different things with these trials, and sometimes I will do members only like chat, stuff like that, ask you guys poll questions behind the scenes, things of the like. You guys help me come up with interviews if we bring lawyers in, things of the like. So thank you so much for joining the membership. Shout out to Kay Tally Pitt Love with the 20. She says thank you for covering this case. RIP Charles Jones. He was a troll, but he was still human. Yeah, I think I responded when you put this in the chat. I mean, like, I do feel bad for Fulio's mom sometimes. Like, she lost her son and he was so young. Yes, he was a troll, but these boys are also young. I mean, y'all YNs are running around just crashing out. Like, it's crazy, So it's tough to watch young people lose their lives in their 20s and, not fulfill their fullest potential. So I was working on getting her to come on the channel right around Alicia's sentencing, but I wanted to wait until the sentencing happened, and she was supposed to come on the next day. Of course, the sentencing did not happen, and I couldn't get her to come on. We're just working on scheduling. We're going to see how this plays out, and then I will absolutely have her on. I'm also just watching the court rules because these guys definitely watch YouTube. Some of y'all were in these motions. Like, y'all were in the motions. Your usernames were in Alicia Andrews' motion saying that the judge was being biased. It was crazy. So thank you so much, Tally. Really appreciate you. Shout out to Jay Kelman, been with me for 4 months, says excited about these upcoming trials. And there's more. Y'all remember, the Tupac murder case is still open. Keefe D is going to trial, I think, in like July. So that's our summer case. Like, that's just a random outlier. They've moved that a lot. Word on the street is that Keefe D has colon cancer. So I don't know why they keep moving it out, but it is time to go to trial for that one, right? So we're going to see what happens with that one. Dirk got moved to August, but Dirk is federal, so we're not going to have cameras in the room, okay? So y'all keep that in mind. Tally became a member, and then Tally upgraded the membership. Shout out to Tally. Thank you so much, and thank you for also enhancing your membership too. Like, when y'all support the channel, you don't understand how far it goes. I have an editor that comes up. He's like my right-hand man. He helps me with everything. That means the titles, the thumbnails, the video editing, all of that stuff, we tag team it. So this actually helps the operations of, my YouTube channel. So I appreciate when you guys become members and donate to the streams, things of the like. But thank you so much, Tally, for upping your membership. I covered this one with Messy Michonne live. Y'all check her out as well. And then lastly, the International Quiet Storm with the 5 says, buckle up, AV. Do you think this case will rival the Darrell Brooks case in terms of ratchetness? You never know. But what I am curious about, because nothing is going to be like Darrell Brooks. That whole case was crazy. He's yelling at the judge, hiding behind boxes, representing himself. Like, that was wild. Staring at the judge. Poor judge was scared of him for a while. She had to put him in another room. He's putting, what was it, Cornholio from Beavis and Butthead. He's putting his t-shirt over his head in that way. Like, that case was a circus, but this one I don't think is going to be that bad. It gives me undertones of logistically the YSL case. I think that's why she blocked it out for about 6 weeks, because it's 4 defendants right now. Maybe there's a severance, but knowing Judge Sisco, she denies a lot of motions. So she might try them all together, right? But it's 3 death penalty sentences, not 4. So we're going to see what happens there. But yeah, as far as ratchetness, the thing that makes me the most curious is we went through Alicia's presentation of the case. Like, we saw what the state said that she did, right? A lot of it. And you guys remember Jeremy. What was his question? What was his first question? Do you know Alicia Andrews? Did Alicia Andrews do this? Is she depicted there? Do you have evidence of Alicia? Now, in this scenario, you actually have evidence of the boys and what they did. You have them on camera. You have them at the McDonald's. You have them in pictures. You have the plotting and the planning. You have, Sean just, caught red-handed cleaning the car. They were just trying to get that count removed. She denied it, right? But you have a lot more evidence that implicates the boys. So I really want to see how the state is going to present this case to the jury. And I also want to see how the boys are going to try to defend this. Like, how? You're cooked. I mean, even if Sean, because Sean has some pretty interesting motions that are outstanding right now, like the whole iCloud thing, right? And how that scope wasn't limited. But the reason why they're using that with the whole fruit of the poisonous tree thing is because of the mom, and the code. That came out in the last trial. A lot of that evidence is still fair game, right? So you have that whole thing. Then on top of that, Alicia's situation was a little bit different. She didn't pull any triggers, but, at the same time, she was also involved. That's arguable because people are like, oh, well, she was just on a romantic getaway. Other people are like, no, she's cooked too. But at the same time, the appeals court thought the judge was biased and had her removed. I mean, that's just what it is at the end of the day. They didn't give us any rationale behind that. They just said appeal granted. So it's going to be interesting. But to see it from a different perspective, where it's coming from the boys defending themselves, but it's also the state has to kind of pivot. And I did notice from this hearing as well, you heard them kind of anticipate some of the mistakes that happened in the Alicia trial, especially with Robert Howard, right? Like some of y'all were talking about that in the chat with Robert Howard coming on, and it is alleged that he is the one that murdered, I think it's Davion's brother or one of the cousins' brothers, right? If he's the person that's testifying, and remember last time he didn't want his face on camera. So his face was not on camera. We just heard him testifying, right? So it is going to be interesting to see how all of that plays out. Sean's witness list so far is pretty interesting too. He has a lot of his own family members, and I'm pretty sure his mom is going to be on there. The grandma, I believe, is going to be on there too, and maybe the sister. There's some repeat people as well. So some of the women that testified last time in Alicia's trial are going to be testifying here as well. Like I think it was some of the young girls that were with Foolio and things of the like. The state may call them too. So, we'll see. So we have one witness list from Sean's team, but I want to see who Davion wants to call. I want to see who Isaiah Chance wants to call. Are they going to call Alicia? Alicia didn't call any of these kids. So we'll see who gets called to the stand. But do I think it's going to be a dumpster fire? Possibly. These lawyers seem to have their own personalities. I mean, if Davion's my client and he's over here like, hey, boo, hi, that's my baby. Like, all right, are we really focused over here? What are we doing? I'm trying to get you out of jail, man. Like, I don't know if he's going to get out of jail, but just thinking about that criminal defense. So with big trials like this, it's kind of fun too, because we start to develop different, we get like fan favorites with some of the defense attorneys. Like we're like, oh, this one's good, that one not so much, this one's weak, this one's okay. And then you've already seen these prosecutors and how they perform. We know what their habits are. Like the redhead, I think, is the fiery one on the team. Like when she goes in and she becomes ChatGPT and she starts asking those questions very fast, it gets real. It gets very real, and she doesn't take bullshit from the other side. So she will go right back on in and cross. I think she is like the strongest that they have on cross-examination. Now, the other woman, she did the closing argument in the Alicia trial. She does take her time with questions. So I do worry about her as a prosecutor sometime. And Mr. Harmon can be a lot. But, he did have a lot of fire going towards that defense team in Alicia's trial. So we'll see what happens here. So many of you guys have been curious and asking questions and leaving comments about how Judge Sisco is even able to preside over this when there was bias found in Alicia's case. Well, we're at the preliminary start of this trial. This trial hasn't started yet, so you can have an issue with the judge, but if you're assigned this judge, you're assigned this judge for now, right? So it's gonna be a long April, but that's what we have on the docket so far. All right, y'all. I am going to pop on out of here. All the ways that you can support the channel are in the description box. You guys see the International Quiet Storm. When we do go live for the trial, you might see some of the mods with blue wrenches. Just show different ways to do that. They're really here to help me. So if somebody's like, hey, where's the merch store? How do I become a member? Things like that. You will see people with blue wrenches kind of drop those links, things of the like, if you're new here. Let me know what you think about all of this in the comment section. Y'all know how I do. I like to chop this up into chapters. So if you miss a certain part, we do that about an hour after the stream ends. So if you want to go back and look at a specific part, you can do that. So I'll break it out per defendant and what their motions are, because there were some spicy moments. And sometimes like I'll put like a fire emoji if something funny happens. In this case, it's my baby, call me. I'll be calling you, answer the phone, those type of things. So we'll see if Corey Holcomb's stunt double comes with a new message and a new notepad moving forward. But all right, y'all, let me get out of here. Have a wonderful Friday. Make sure that your notifications are on. Let me know what you think in the comment section below, and we will see you guys in the next one. Stay safe out there. Bye.